Very good morning. I would like to ask participants to take the seats. We'll be starting in about 2-3 minutes. Thank you. A very good morning. My name is Marcin Walecki. I'm head of Democratization Department with Office for Democratic Institutions and Human Rights. It is my great pleasure to welcome all of you, and particularly our dear director, to the working session number 4. The working session number 4, Rule of Law. We will discuss the issues related to independence of judiciary, right to a fair trial, democratic lawmaking. And I am extremely pleased to announce that we will have 3 introducers, and I will briefly introduce them in a second. But please allow me just to make a few traditional housekeeping remarks, how we're going to conduct this session, and I'm to your disposal as a moderator. First of all, let me just remind you that the speaker list is at the back of the head table, and I think we already have 49 speakers, so we have a 1 slot left. So whoever can run to Rita would be the last speaker, and then I will have to close the speakers list. So we have a 1 slot left if anyone would like to register as a speaker. I would also like to remind the speakers that they can take the floor in the capacity in which they are registered, and only entities registered on the speaker list can be represented. I would also like to remind ourselves that live streaming of the 2018 HDIM is available. Filming with cameras and video cameras is only permitted by accredited journalists. No other audiovisual recordings should be undertaken without the explicit permission of individuals being filmed. I would like to remind participants that it is expected that interventions are presented in meaningful, orderly, and respectful manner, and I would also like to encourage all participants to submit their statements before the session to the interpreters and preferably to distribution center. The brief bios of our introducers will be displayed in the screens. And please allow me now to once again welcome our introducers. We have 3 distinguished speakers, And our first introducer would be Ms. Nina Beteto, who is the judge of the Supreme Court of the Republic of Slovenia and Vice President of the Consultative Council of European Judges of the Council of Europe. Justice Beteto, the floor is yours.
Thank you. Ladies and gentlemen, good morning. The rule of law as an organizational model of modern constitutional law and supranational and international organizations serves the regulation of public power. At its core, the rule of law ensures that all public power is exercised in accordance with the laws, human rights, and democratic values. Possible abuse of power within the democratic process is controlled by independent courts. An independent and impartial judiciary is one of the cornerstones of the rule of law. However, the practical ways in which this is given effect are often treated with suspicion. For example, judges are given immunity from prosecution for any acts they carry out in performance of their judicial function. They are selected, not elected. They also benefit from the security of tenure until the statutory age of retirement. These principles have led some people to suggest that judges are somehow above the law. There have been comments such as the enemy of the people remark, or judiciary should be given back to the people. Judges are not above the law. They are subject to the law in the same way as any other citizen. Judges are subject to evaluation procedures of their performance. Disciplinary and criminal proceedings may be initiated in order to establish whether it would be appropriate to remove judges from office in circumstances where they have been found to have committed a disciplinary or criminal offense. Judicial independence does, however, mean that judges must be free to exercise their judicial powers without interference from litigants, the state, the media, or powerful individuals or entities, such as large companies or political parties. This is an important principle because judges often decide matters between citizens and the state, and between citizens and powerful entities. Individuals involved in any kind of case before the courts, being criminal or civil, need to be sure that the judge dealing with their case cannot be influenced by an outside party or by the judge's own personal interests, such as subjective considerations linked to his or her promotion. This requirement that judges be free from any improper influence also underpins the duty placed on them to declare personal interests in any case before it starts, to ensure that there is neither any bias or partiality or any appearance of such. A practical example of the importance of judicial independence is where a high-profile matter, which has generated a great deal of media interest, comes before the court. Such matters range from the criminal trial of a person accused of a shocking murder, the divorce of celebrities, and challenges to the legality of a government policy, for example, the adequacy of government planning policy or the deportation of persons because of their criminality. It is reasonable to believe that the judge hearing such case will often be under intense scrutiny, with decisions open to intense debate. It is right that this is so, but it is important that decisions in the courts are made in accordance with the law and are not influenced by such external factors. Ladies and gentlemen, what is the current state of play as regards the independence of judiciary? The problems regarding the independence of judges as a whole are very serious and worrisome in several countries. As a general observation, there is no strong commitment to strengthen the rule of law. In some countries, it is even the opposite. Infringements of judicial independence are related to appointment and security of tenure of judges, functioning of councils for the judiciary and the administration of courts, impartiality of judges, codes of ethics and professional conduct, and disciplinary measures, economic basis for smooth functioning of the judicial system, public discussion, and excessive criticism of judges. I would like to address just one point. That is functional and organizational independence of judiciary. In the light of the importance of the rule of law for a functioning and free democratic society, developments in several countries, especially the idea to establish real and effective control over the judiciary exercised by the current political majority in the legislative and executive branch of power, seem to remarkably stray away from the modern understanding of a democratic state that adheres to the principles of the rule of law. In this respect, the relationship of the judiciary with other branches of government from the perspective of the rule of law should be clearly reiterated. The law is applied by the judiciary, which exercises its power independently of either the executive or legislative powers, and individual judges and base their decisions solely on facts and law of individual case. As the Venice Commission has stated before, judges have a duty of ingratitude towards the authority that selected or appointed them. An appointment in accordance with the laws and the Constitution only partly legitimizes a judge. If democratic legitimacy were sufficient to establish a judiciary that can fulfill its role as required by the rule of law, the direct election of judges by the people would seem like a logical and reasonable consequence. For good reasons, this model has never been seriously considered in almost all European countries. Solely focusing on democratic legitimacy carries its own risks. Namely, the involvement of politics in the selection of judges bears the risk that outside criteria might play a role in selecting judges. Most notably, focusing on democratic legitimacy would allow for appointments based on political considerations aiming to serve the will of the current political majority. Human rights standards, such as equality before the law, presumption of innocence, and the right to a fair hearing, are relevant to judges at all stages of their work. Judges need to be well qualified and personally independent and impartial. They can earn functional legitimacy by performing their duties according to the highest standard of professional conduct, which requires a high degree of self-awareness and humility. It is not the task of judges to decide cases in the way the current political majority would like them to decide. A functioning judicial system that is to serve the rule of law can never depend on what the majority, however democratically legitimate it may be, wants or desires. To conclude, a judge's decision can and sometimes must be unpopular. This is a necessary element of a functioning judiciary that serves the rule of law. As Avocat General Mr. Maduro observed in the famous Cadi 1 case, the responsibility of the courts is to guarantee that what may be politically expedient at a particular moment also complies with the rule of law, without which, in the long run, no democratic society can truly prosper. Thank you very much.
Thank you very much indeed, Justice Bettetto. I would like now to introduce our second introducer, Ms. Simona Granata Meghini, who is Deputy Secretary of the Venice Commission, Council of Europe. Madame Granata, the floor is yours.
Thank you very much. Ladies and gentlemen, it is a great pleasure for me to be here today to represent the Venice Commission of the Council of Europe and to participate in this discussion with such distinguished speakers and participants. The Venice Commission and the OSCE ODIHR have been close partners and have played coordinated and interrelated roles in promoting our shared values and in assisting member states in abiding by international standards in their legislation and in the democratic development of their institutions. The Venice Commission and the OSCE ODIHR in particular have provided legal opinions, legal assessments, non-binding joint assessments on draft legislation and have provided recommendations to improve these texts. This advice is based on international standards, hard law standards, soft law standards, and also on comparative material, that is to say, the practice of other states in comparable situations. This all makes up what we call the European or common constitutional heritage. And I wish to stress in this respect that these standards are not manufactured and imposed on states from the outside. They are not an external diktat. These standards are the result of the joint work and joint efforts of the international mechanisms and bodies in which the relevant member states participate. International standards are the collective outcome of the individual inputs of each member state into the standard setting machinery. And this means that member states may not simply opt out. They may not just disregard the standard or the international judgment which they disagree with. As long as they are part of the system, they must accept ownership and responsibilities for these standards. This does not mean to say, however, that these standards are all fully binding and are all developed in all details. In many areas, standards are at the level of obligations of result, not of obligations of means. The Venice Commission and the OSCE ODIHR have provided help in filling the gaps and devising constitutional and legislative solutions that meet at the same time the international standards and the diversity of each state. Ladies and gentlemen, today's session is about the rule of law, and in particular about the independence of the judicial system. In this area, the Venice Commission has elaborated a rule of law checklist which identifies the core elements of the rule of law and presents them in the form of detailed benchmarks, which also expressly mention their source. The checklist has been endorsed by the Committee of Ministers, by the Parliamentary Assembly, and by the Congress of Regional and Local Authorities of the Council of Europe. And it is a tool which is at the disposal of the authorities, of the civil society, of academia, of international organizations, and all those who wish to provide an assessment which is thorough, objective, transparent, and equal. And of course, the checklist identifies the independence of the judiciary and fair trial as one of the core elements of the rule of law. Independence, as you all know, and as was reminded by the previous speaker, Ms. Benetto, means that the judiciary is free from pressure and that is not subject to political influence or manipulation, in particular from the executive branch, but also from Parliament. Independence means that the Public Prosecutor's Office is not permitted to interfere in judicial cases outside its standard role in criminal cases. Independence means that individual judges take decisions only on the basis of the Constitution and the laws, and not on the basis of instructions given by higher-ranking judges. Independence means that the judiciary is not corrupt, and it's shielded from corruption. Independence goes hand in hand with impartiality. An independent judiciary doesn't do politics, it does law, and it does law equally for everyone. Everyone is equal before the law when the judiciary is independent. For this to happen, solid guarantees for independence, both external, which means from undue external influence, and internal, which means from undue hierarchical influence within the judiciary itself, must be provided, first and foremost in the Constitution and then in the legislation. Let me stress at this point that judicial independence must not be a shield from public scrutiny. Public scrutiny and indeed accountability of the judiciary are an essential precondition for public trust, which in turn is essential for the judiciary to perform its key role in a democratic state governed by the rule of law. Independence and accountability are interrelated and multidimensional concepts. A judiciary which is not accountable to society risks being blind to the needs of the society, but accountability without independence reduces the judiciary to a government agency. The judiciary must be insulated from undue interference that may be exercised through political economic means, but the judiciary must not become a closed shop, where judges act for their own benefit or for the benefit of their category and not for the benefit of the society. Corporatism and undue peer restraint must be avoided. The judiciary should enjoy the respect and the trust of the public, and for this to happen, it is also essential that the other branches of power refrain from attacks on the judiciary. Judicial decisions may be criticized, but must be respected and executed. Accountability means transparency about performance. It is accountability towards the society, not towards political and economic powers. The search for the right balance between independence and self-regulation of the judges is visible in the very diverse formulas which have been used for setting up judicial councils. But we must not only see the independence of the judiciary as a structural element of the state, as a skillful combination of provisions in the Constitution. The independence of the judiciary is realized and respected through the acts of each judge, of each state representative, of each state institution, and also of each citizen, every day. Otherwise, it remains on paper. Ladies and gentlemen, another core element of the rule of law, according to the checklist, is legality, which also covers lawmaking procedures. This procedure must be transparent, inclusive, and democratic. In a representative democracy, Parliament has the mandate to prepare and enact the laws, but the public must be given the possibility of providing a meaningful input in the preparation of at least the most important ones, and certainly the Constitution. In a functioning democratic society, there are various ways in which the public may convey its views and positions to the government and Parliament, through articles and interviews in the media, through public debates, through peaceful demonstrations. These are all legitimate means which should not only be tolerated, but also encouraged by the authorities. But this is not always sufficient. In many cases, for example, in the case of constitutional amendments, as I mentioned, of electoral laws, of laws affecting national minorities, or laws affecting NGOs, the public, experts, civil society, representatives of the minority groups should be specifically consulted and in a meaningful way, which means that the authorities should engage in genuine discussions and provide explanations as to why certain objections and arguments put forward during these consultations do not deserve to be followed. Meaningful also means that the parliamentary procedure should follow its ordinary course, should not be rushed, should provide for adequate time for full reflection and scrutiny by all MPs and for public debates. Urgent procedures should only be reserved for genuinely urgent cases. What is at stake is the legitimacy of the Constitution and the laws, the feeling of ownership by the people, which is the only real guarantee that the Constitution and the laws will be truly implemented in practice. Ladies and gentlemen, I look forward to your comments and thank you for your attention.
Thank you very much indeed, Madam Deputy Secretary. It is a great pleasure now for me to welcome our third introducer, Professor Murray Hunt, who is a director of the Birmingham Center for the Rule of Law and a professor at Oxford University. Professor Hunt, the floor is yours.
Thank you very much indeed, Moderator, Madam Director, Madam Chair, Excellencies, ladies and gentlemen. It's a great honour for me to be with you all here this morning. I look very much forward to your discussions in this session. These are very challenging times for the rule of law, not just in developing countries or recently democratized countries, but in the well-established democracies. In the United States, from where I returned recently, the rule of law and judicial independence are constantly in the news. This week, the story is the assault on the legitimacy of the International Criminal Court. Last week, it was the calling into question of the decisions of US courts and prosecutors in the high-profile convictions of the President's former advisors. In my own country, the United Kingdom, the ongoing process of leaving the European Union following the 2016 referendum throws up daily challenges for the rule of law, including media attacks on judges as enemies of the people. Here in Central and Eastern Europe, as we saw debated in the European Parliament yesterday in the case of Hungary, there's a clear trend towards the assertion of political control of the judiciary, amongst other independent institutions which provide the crucial checks and balances to ensure that elected politicians do not abuse the very considerable power and trust placed in them by the people. These challenges to the rule of law cannot be attributed to individual political leaders, tempting though that might be. They're the product of much deeper forces and longer-term trends affecting our societies and our world. A resurgence of nationalism, isolationism and protectionism, the reassertion of national sovereignty, and a general retreat from multilateral cooperation and international obligations. As this week's elections in Sweden reminded us, there's an increasingly receptive audience for the xenophobic messages of political leaders which pose fundamental challenges to our human dimension commitments. In these troubled times, we need to recall the interdependence of the three foundational commitments to the rule of law, human rights and democracy. In particular, in this session of our meeting, we must remember that the rule of law is a precondition of the other two. There can be no democracy or human rights without the rule of law. We also need to remind ourselves of our shared responsibility for upholding these fundamental commitments. The rule of law, for example, is not the sole responsibility of the courts to uphold. It's the responsibility also of the other branches of the state, the legislature and the executive, to uphold and to promote the rule of law, as well as private actors and individuals. At this historical moment, when both the rule of law and some would say democracy itself are facing these existential challenges, I therefore want to focus my comments on the connection between two specific aspects of the rule of law that we're considering in this session: judicial independence and democratic lawmaking, in order to demonstrate this interdependence and shared responsibility. These are two important aspects of the rule of law on which OSCE participating states have adopted many detailed standards. So what does it mean that there is a shared responsibility for these aspects of the rule of law in practice? I want to ask two questions. First, what is the role of the legislature in upholding judicial independence? And secondly, what is the role of an independent judiciary in promoting democratic lawmaking? As we shall see, courts and parliament both have a strong mutual interest in upholding and promoting each other's constitutional function. And for a rule of law culture to grow and to flourish, there must be a clear division of powers between different branches of the state, with the legislative, executive and judicial branches responsible for different functions, and a clear and respectful understanding of both the limits of those functions and of the legitimate role of the other branches. So to turn to the role of legislatures in relation to judicial independence, how can parliaments contribute to the independence of the judiciary? Let's start with the obvious things that legislatures should refrain from doing because they undermine judicial independence. First, parliamentarians and legislatures generally should refrain from attacking courts and judges in terms which undermine their legitimacy. Courts and their decisions should not indeed be beyond criticism. It's important in a democracy that their decisions are carefully scrutinised, analysed and debated. But there's an important distinction between criticism and abuse. Individual judges should not be publicly vilified for their decisions, nor cast as enemies of the people. Criticism should be of decisions, not judges, and should be conducted in terms which are respectful of the individuals and of the importance of the independent judicial function in a democracy. Second, legislatures must refrain from passing legislation which subjugates the judiciary to the control either of itself or the executive. This is currently one of the greatest challenges facing the rule of law. Legislatures which are either controlled by executives which themselves want to control the judiciary, or which are complicit in such efforts by failing to scrutinise with sufficient rigour legislation which is designed to have that effect. So we see in a growing number of countries legislation being passed which confers too much power on political actors in crucial decisions about judges such as appointments, retirement, discipline, removal and deployment. These are both negative obligations on the legislature, not to undermine judicial independence. But there are also many positive things that legislatures can and should do to promote judicial independence. First, legislatures should put in place the detailed legal framework which ensures that neither the executive nor the legislature can control the judiciary, by ensuring that the framework guarantees security of tenure and contains the independent machinery necessary to protect the judiciary from interference by the powerful. Decisions about appointments, discipline and removal must not only be free from political interference, but they must be taken by bodies which the public can be confident are genuinely independent. And there is now a rich and well-established body of international principles on these matters for legislators to draw upon when they are designing this legal framework. Second, legislatures should rigorously scrutinise all government legislation which has implications for judicial independence, measuring it against the detailed international standards. They should seek expert help to identify both the issues that need scrutiny and the relevant standards, and should probe deeply the government's justifications for the legislation. Where necessary to secure compliance with such standards, they should amend the legislation. From my experience of many years advising the UK's Joint Committee on Human Rights, I know that there's enormous scope in every parliament to improve the way in which such scrutiny is carried out. Third, legislatures should hold the executive to account for its own responsibility to uphold judicial independence. They should monitor and scrutinise all aspects of government policy that can affect such independence, including budgetary matters such as judicial salaries and pensions, the amount of resources allocated to the justice system, and infrastructure questions such as court closures and the digitalisation of justice. In addition to this essentially reactive role, legislatures should be proactive in their scrutiny of the executive's responsibility for promoting judicial independence. An example of a specific measure which has proved effective in practice is the statutory duty that the UK Parliament imposed on the Lord Chancellor to uphold the rule of law and to protect the independence of the judiciary. When the Lord Chancellor failed to defend the judges against the media's characterisation of them as the enemies of the people, it was the chair of the Justice Committee in Parliament, along with other parliamentarians, who eventually forced a response from the Lord Chancellor, the member of the government, by invoking this statutory duty in questions in Parliament and in parliamentary committee correspondence. Fourth, in all this important work, legislatures should engage closely with the judiciary. Without seeking to hold them to account for their decisions, they should take evidence from them regularly about the operation of the justice system and should consult them about legislation or government policy which has significant implications for judicial independence, or the justice system generally. In the United Kingdom, the Lord Chief Justice regularly gives evidence to the House of Lords Constitution Committee, and other judges also give evidence to other relevant parliamentary committees such as the Human Rights Committee and the Justice Committees. Let me turn to my second question. Just as legislatures have an important role to play in upholding and promoting judicial independence, so courts also have a crucial role to play in upholding and promoting another fundamental aspect of the rule of law, democratic lawmaking. How can an independent judiciary make this important contribution? First, independent judiciaries should show restraint when necessary, so as not to encroach on the appropriate role of the legislature or the executive. They should demonstrate thoughtful consideration of the limits of their own function, so as to avoid unnecessarily calling their legitimacy into question. Second, an independent judiciary can help protect Parliament against executive usurpation of the legislative function. For example, in the UK, courts in the litigation around the EU's exit from the UK's exit from the EU forced the government to consult Parliament before it triggered the process under Article 50. This was a significant judicial intervention in the service of safeguarding Parliament's role when it was in danger of being sidelined by the executive. Similarly, an independent judiciary can also protect Parliament's role by ensuring that executive lawmaking, for example through delegated legislation, stays within the scope of the lawmaking authority that the legislature has delegated. Third and finally, courts have an important role to play as enhancers of democracy by encouraging compliance with the requirements that democratic lawmaking must be inclusive, transparent and accountable. They can incentivise such compliance by scrutinising legislation for compliance with such standards and being prepared to criticise the government or the legislature where necessary and justified for departure from such standards. For example, where there's been inadequate consultation of affected parties before legislating, or insufficient time has been made available for the legislature to perform its important scrutiny role. And it's an important part of this judicial function that courts must also be prepared to apply a doctrine of due deference to the legislature when that is warranted, upholding challenged legislation which has been made in compliance with the requirements of democratic lawmaking and the fundamental standards the state is committed to. Ladies and gentlemen, I've sought to draw out some of the linkages between judicial independence and democratic lawmaking and to provide some good examples of good practice. I believe that it's by exploring these connections through the important lens of shared responsibility that we can best refine and develop our human dimension commitments and improve our procedures and mechanisms for monitoring their implementation. And I look forward to continuing to work with OSCE to redouble our efforts to meet the urgent challenges to the legitimacy of our institutions in these troubled times. Thank you.
Thank you very much indeed, Professor Hunt. I would like to thank once again Justice Betteto, Secretary Granata, and Professor Hunt for their very constructive, excellent, sharp introducing remarks. For all of us who would like to get a copy of those introductory speeches, speakers kindly submitted their speeches to the distribution center. So I'm confident that those speeches will become a part of our rule of law reading list in the future. I have a good news and bad news. The good news is that actually this session proved to be very popular. We closed our speaking list. We have 50 speakers on this speaking list. And I'm afraid the bad news is that I had to cut the time to 2.5 minutes for each speaker. And I hope we will be working together to make sure that this session conducts in a professional manner, and will manage to finish on time. I would like to remind once again the participants the topic of the session. This is a rule of law session. We'll discuss issues related to independence of judiciary, right of a fair trial, and democratic lawmaking. And I would like to encourage all the participants to keep their comments brief and to the point, listing, first of all, recommendations. And for those colleagues, and I do apologize again, we have a limited time, who have prepared statements, don't hesitate to submit them to the documentation distribution center. Now I would like to give a floor to the audience, and we will have the speakers, the list of introducers on the screen, and the first is on our list is Austria on behalf of the European Union, followed by Ukraine. Delegation, Austrian delegation, the floor is yours.
Thank you, Mr. Moderator. And the following countries are aligning themselves with the statement: former Yugoslav Republic of Macedonia, Montenegro, Albania, and Iceland. Following your call, I would like to start by offering the following recommendations. Firstly, participating states should ensure full respect for the independence of the judiciary and the separation of powers in line with international standards and commitments. Secondly, participating states need to support the involvement of civil society and other independent actors with regards to judicial and prosecutorial services, including through trial monitoring in order to improve transparency and accountability. Thirdly, participating states should step up their efforts in realizing the Sustainable Development Goals, and in particular, Goal 16. Fourthly, participating states need to establish appropriate legal and legislative frameworks to prevent and address all forms of discrimination and violence against women, and to secure their empowerment and full access to justice. Ladies and gentlemen, the EU reaffirms that human rights, the rule of law, and democracy are interlinked and mutually reinforcing, and that they belong to the universal and indivisible core values and principles. The rule of law is inextricably linked to the protection of human rights and fundamental freedoms. We recognize that all persons, institutions, and entities, public and private, including the state itself, are bound by just, fair, proportionate, and equitable laws. Every person, institution, and entity is entitled without discrimination to equal protection by the law. Independence and impartiality of the judiciary is necessary to ensure the rule of law and to guarantee the right to fair trial for all. Selectivity in the arbitrary exercise of powers in the application of the law needs to be avoided. Strengthening the rule of law is a responsibility for all of us, the EU and its member states included. We are prepared to recognize the challenges that we need to address ourselves and indicate our willingness for dialogue on how to strengthen the role with others. The EU notes with concern steps taken by some governments in the OSCE region to dismantle the rule of law by undermining the independence of the judiciary and openly challenging the principle of separation of powers. We would like to reiterate that any alleged wrongdoing must be subject to a fair trial, to due process, and a swift and effective remedy in compliance with the rule of law and independence of the judiciary. In this regard, I would like to refer once again to the concerns the EU raised in detail in the statement during the opening session with regards to the current situation of the rule of law in Turkey and the Russian Federation, in particular the cases of Mr. Oyub Titiev or the illegally detained Ukrainian citizens in Ukraine. The EU reiterates its call for their immediate and unconditional release. A full version of this statement will be shared with documentation of the conference, including a list of the aligned states. Thank you very much.
Thank you very much indeed, and thank you for observing the time. The next on our list is Ukraine, followed by Russian School of Defense Staff.
Thank you so much, Mr. Moderator. The evaluation and competition procedures in Ukraine with all judges is one of the most important part of the judicial reform. The Commission is a collective body within the judiciary system in Ukraine and consists of 16 members. 10 of us are judges or retired judges. 6 of us are academicians or advocates. As for me, I am a chairman and I am not a judge. I am an advocate and professor of international law. The youngest of us is 40 years old, the eldest 70. The High Qualification Commission of Judges last year finished the first open competition to the new Supreme Court, and open and transparent, and we selected 118 judges. 46 of them are female, as well as the chairman. of the court is also female. It is the first time in the history of Ukraine. For this year, our priorities are the following: the qualification assessment of judges, of all judges of Ukraine. We already finished to evaluate for the evaluation of 1,800 judges, and also we continue to make this procedure for other 3,000 judges. The second priority is selection candidates to district courts, and we had 5,300 candidates for 700 vacancies. We also continue the competition to the intellectual property court. It is also the first time when we create such kind of specialized court in the country. We already started another competition to the Supreme Court for 78 vacancies, and we already announced the competition to the Anti-Corruption Court. It is also the first time when such specialized court is created in our country. You can see that judges, academicians, or advocates with the experience of more than 10 years can be candidates to the Supreme Court, and judges with experience with more than 5 years and other candidates, academicians or advocates can be future judges, candidates, or if they have more than 7 years experience. If to speak of the High Anti-Corruption Court, we announced the competition for 27 positions of judges to the first instance and 12 positions to the appeal chamber. We received 782 notices of intention from people who take part in this competition. A special institution which is called...
I'm really sorry, if I can ask you to submit the presentation to the distribution center and conclude. We really appreciate it. Thank you.
It is always. Thank you. The special institution, the Public Council of International Experts, in accordance to the law, will assist us to evaluate candidates, and we will have 12 candidates and will nominate 6 members of Public Council who will be representatives from international organizations which assist Ukraine in struggle with the corruption. Now we have the new competition to the 78 vacant positions to the 4 cassational courts.
I'm really sorry, but I would suggest, please, you have 10 seconds to conclude.
Thank you so
please.
much.
Yeah, thank you. The next speaker on our list is Russian School of Defense Staff, followed by CIS Europe Monitoring Organization. Пожалуйста.
Good morning. I represent Latvia. Our organization protects Russian schools in Latvia from being destroyed. I must say that with democratic legislation, everything is fine in Latvia. All our laws are exclusively approved by the democratic majority in parliament. The problem is that 61% of the population of our country are ethnic Latvians. And they use their democratic majority to build a Latvia only for Latvians. The first law that was passed after independence was the law on citizenship, which meant that half of the Latvians no longer had the right to vote or to be elected. Since that time, amongst the voters in Latvia, 75% are made up of ethnic Latvians. In using their democratic majority, they pass laws against us, without us, and basically against us. 37% of the Latvians who speak Russian are now a minority language, just like Swahili or Chinese. Municipal and state bodies are not allowed to use it. Russian is not allowed to be used in governance, and Russian schools are now being destroyed, the history of which in Latvia makes up something like 200 to 300 years. The ethnic majority has amended the constitution that states that Latvia is a country of ethnic and for ethnic Latvians. This means that Latvia is officially now an ethnocracy. We support and would like to stand up for Russian schools. We are against the democratic laws passed by a democratic parliament that states that Russian schools in Latvia will be destroyed. And ethnocracy is trying to oppose us. Some special laws were passed on state security. As a result, this year, 14 criminal cases have been started, and 3 people have spent time in jail, including myself. I would like to draw the attention of the OSCE to the fact that our eyes and our hopes are on you. We hope that you will ensure for democracy not to turn into an ethnic autocracy, for democratic laws not to be abused by the majority. Thank you.
The topic of the session is the rule of law. The focus is on independence of the judiciary, right to a fair trial, and democratic lawmaking. And I would like to encourage all of us to stay within the framework of this topic. The next on my list is CIS Europe Monitoring Organization, followed by Russian Federation. Thank you.
Thank you, Mr. Moderator. My name is Alexey Simonov. I'm a political scientist, and I would like to raise the issue of politically motivated persecution in the OSCE region. In April, in Riga, the human rights activist, the head of Latvian Non-Citizens Congress, Alexander Gaponenko, was arrested. He was in prison until August. He is known as a fighter for the rights of the Russian-speaking population of Latvia and as a vocal critic of the Latvian school language reform. In December, the Latvian security police launched a criminal trial against opposition journalist Yuri Alexeyev. In view of the fact that both of them were known for their pro-Russian minority views, their arrest on the eve of the parliamentary elections in Latvia looks politically motivated. In July, a Russian citizen, Maria Butina, was arrested in Washington, D.C. In Russia, she is known as the leader of the Right to Arms NGO. She actively criticized the Russian arms legislation and laws on self-defense. She usually addressed the American traditional way of life, gun culture, and the Second Amendment to the US Constitution as a positive example for Russia. However, she was arrested not by the Russian Secret Service, but by the American. The US Justice Department accused Butina of working as a foreign agent. She tried to make contact with the National Rifle Association. Perhaps I understand nothing about spycraft, but I think spies would hide the fact that they are connected with Russia. However, there was nothing covered about her activities. Putin's attempt to improve relations between the two countries may seem ominous only if we look at it through the lens of the Cold War. The fact that Putin was arrested on the eve of the meeting of Donald Trump and Vladimir Putin in Helsinki gives reason to believe that this arrest was politically motivated. Yet I believe we should not sacrifice human rights to the crooked geopolitics. Russian lives matters. Thank you for your attention.
Thank you very much. It is my pleasure now to give the floor to Russian Federation, followed by United States of America.
Mr. Chairman, distinguished participants, one of the most crucial guarantees of human rights is the defendant's right to a fair trial, including the access to justice, as well as the right to the execution of the court's decision. Unfortunately, in the OSCE area, we have often seen the trampling of the principle of rule of law and international law. Of course, we cannot talk about any fair access to the justice system under these circumstances. We are extremely concerned by the infringement of human rights in Ukraine. We know that the fundamental guarantees are not being extended to detainees. They are being accused of being involved in armed conflicts in Ukraine, southeast of Ukraine. The victims have said that, first of all, they are detained in secret jails where they are interrogated for several days on end before being transferred to the official penitentiary system. And the victims have also talked about being brutalized, tortured with electricity, simulated execution, strangulation, intimidation, and threatened with sexual violence. Another blatant and grievous violation of systematic human rights breaches are special jails at Guantanamo by the United States, where 4 40 prisoners, most of which have been there for over 10 years, are being detained in a legal vacuum without being formally charged, and they have been tortured. The illegal actions by the U.S. authorities have spread to other countries. In a number of OSCE participating states, secret CIA prisons were created, where the basic international standards of justice and treatment of prisoners were seriously violated. Those who are responsible for creating the special prisons have not been held to account, in spite of the relevant decisions of the European Court of Human Rights. The unfounded and biased verdicts of the American and British courts, which constitute a false foundation to have detained people from Russia throughout the world. One example is the detainment of Maria Butina, a Russian member of an NGO, under fabricated charges of being an agent of a foreign power without due registration, is really only based on the political problems in the United States. Psychological pressure was used against her. She was deprived of sleep, a lack of exercise outside. She was strip searched after each meeting with her lawyer. All of these cruel and humiliating treatments have been deemed to be torture by the International Criminal Court. Now, she is going to also be placed in solitary confinement, and the Federal District Court, as is well known, refused to place Ms. Butina under house arrest before the trial. Not only does this undermine our efforts in the OSCE in the human dimension, but significantly negatively impact the image of the European Union and the USA as democratic countries. We believe that the rule of law and issues of justice need to be at the constant attention of the OSCE. Thank you very much.
I would like to give the floor now to the United States of America. Ambassador, the floor is yours.
Thank you, moderator. Judicial independence and rule of law are essential to democratic government. More than 180 political and religious prisoners are being held by the Russian Federation. Many have been subjected to cruel practices revived from the Soviet era, such as punitive psychiatric incarceration. Russia must release the nearly 70 Ukrainians it has unjustly imprisoned, including hunger-striking Crimean prisoners Sentsov and Baluk, and Chechen activist Titiev. In Turkey, emergency decrees, restrictive constitutional amendments, and new counterterrorism laws have undermined the judiciary's ability to provide timely and independent justice for over 70,000 citizens detained since the July 2016 failed coup attempt. Turkey must immediately release unjustly detained persons. These include U.S. citizens Pastor Andrew Brunson and NASA scientist Seykan Golay, as well as 3 Turkish national employees of the U.S. mission in Turkey. We urge Azerbaijani authorities to release all of those incarcerated for exercising their fundamental freedoms. They should also lift foreign travel bans on activists and opposition leaders and conduct thorough investigations into reports of abuse in custody, including torture. Priorities for countries of the Western Balkans include bolstering the rule of law, rooting out corruption, ensuring equal justice, access to justice, and prosecuting those responsible for atrocities. The United States encourages Serbia to use its European Union accession as a catalyst to improve independence of the judiciary. Those responsible for the 1999 murders of the 3 American brothers, Bitucci, still have not been brought to justice. Romania has made strides in strengthening the rule of law, but recent changes to Romania's criminal code and code of criminal procedure will weaken the rule of law and the ability to fight crime and corruption. We reaffirm our commitment to the judicial independence in Poland. In Tajikistan, so-called anti-extremism and anti-terrorism laws are misused to restrict political pluralism and target defense lawyers of political opposition members. The cases of Yorov, Makamov are illustrative of this problem. We repeat our call for information on disappeared prisoners in Turkmenistan. There's been no reliable information for years about our former OSCE permanent representative colleague, Ambassador Berdayev. In Kazakhstan, there are allegations of judicial irregularities in several prominent cases. There are also reports of mistreatment and detention. In Ukraine, we welcome the recent establishment of an anti-corruption court, but Ukraine must do more to address systemic corruption and move forward with reforms. And finally, in Armenia, we welcome the new government's progress on investigating corruption. We hope to see concrete reforms to bolster the independence and credibility of law enforcement authorities and the judiciary. Thank you so much.
Thank you, Ambassador. I would like to give the floor now to Human Rights Vision Foundation, followed by Federazione Italiana Diritti Umani, Comitato Italiano Helsinki.
Ladies and gentlemen, Jamshed Yourov, and I am the brother of a political prisoner and lawyer in Tajikistan who has been sentenced 28 years imprisonment because of his activities by the court of Tajikistan, which is dependent on the authorities. I can say with certainty that the judiciary in Tajikistan is fully dependent on the authorities when it takes its rulings and on the investigative bodies and the prosecution. This not only interferes with the work of judges, but it also has an impact on the administration of justice and respect for the procedural code. In Tajikistan, courts and judges are used as tools, and the judges are appointed by members of the ruling party. The ruling party occupies almost all of the seats in the country's parliament. If a citizen or witness is searched before entering the court, their mobile phones and everything are confiscated, and the access to a court hearing is extremely restricted, for instance, for journalists. This places doubt on the decisions of the judges, which cannot be evaluated as to their independence. There is also a lack of information as to how evidence is gathered and presented. This method of administration of judges bears witness to the lack of transparency concerning government prosecutions as well, and the judges cannot be independent from the desires of the prosecution and the authorities. Tajikistan needs to move from merely stating that they abide by principles such as impartial and fair trials to actually upholding those standards. The full text of our report will be transferred to the Secretariat, and I would just like to conclude by saying that, first of all, Tajikistan needs to release all political prisoners, including my brother. Thank you.
Now I'd like to give the floor to Comitato Italiano Helsinki, followed by Global Ukraine Foundation.
Dear ladies and gentlemen, as a member of Human Rights Monitoring Mission to Kazakhstan of the Italian Federation for Human Rights, I would like to draw your attention to the serious problems with the rule of law in the Republic of Kazakhstan. The independence of judiciary is one of the basic principles of democratic states. The Universal Declaration of Human Rights proclaims the principle of equality of all before the law, the presumption of innocence, and the right to a fair trial. In countries like Kazakhstan, where democratic institutions are poorly developed and the rule of law doesn't work, innocent people often become victims of persecution, pressure and restriction. This especially concerns politically motivated cases, where even lawyers and attorneys are attacked by state institutions and authorities. The restriction of the right to defense in politically motivated cases proves an accusatory tendency of the political trials in Kazakhstan. Thousands of politically motivated trials take place in Kazakhstan now. Political prisoners are being treated and charged as dangerous criminals. They are tortured either physically or psychologically, demanding to sign an indictment. Businessman Iskander Yerimbetov, who is a brother of human rights defender and lawyer of exiled Kazakhstani regime opponent Mukhtar Ablyazov, Botagoz Jardemali, was tortured in the detention facility during 1.5 months. demanding that he convince his sister to return to Kazakhstan and falsely testify against Mr. Ablazov. Activist Aset Nurjalbay cuts his vein after psychological and physical tortures in the detention facility. Blogger Murat Tungishbayev was tortured by refusal to provide medical assistance. Political prisoner Mukhtar Jakishev has already spent 9 years in the prison. He almost lost the ability to move because 9 years ago he refused to sign false confession against Mukhtar Ablazov. Citizen of Azerbaijan, Azer Guliyev, was tortured by the National Security Committee of Kazakhstan officers. Then he was acquitted, but now he is waiting for appeal of the prosecutor's office and cannot return to his home. No one was responsible for the crimes against these people. Concluding, the Italian Federation for Human Rights appeals to all OSCE member states to make a constant monitoring of the situation with the restriction of rule of law in the Republic of Kazakhstan to prevent systematic violation of the international obligations and deliberately use torture and politically motivated persecutions. Thank you very much.
Thank you very much. I would like to give the floor now to Global Ukraine Foundation, followed by Freedom Now. Global Ukraine Foundation, the floor is yours. I don't see a representative from the Global Ukraine Foundation. Now we'll move to Freedom Now.
Извините. Уважаемые
Ladies and gentlemen, Dominika Manoli, and I am a judge of the Court of Appeals of the Republic of Moldova in Chisinau. I am a direct victim of a clear political interference in the judiciary. I have been a judge for 27 years now, and last year in July I was fired from the judiciary. For 2 years, the prosecutor's office of Moldova is looking into a criminal case against me. I was a critical voice of the judiciary, and in 2016 I handed down a ruling compelling the relevant bodies to take a constitutional referendum. This decision was then revoked, and a month later the magistrates decided to open a criminal case against me. This case was opened for a travesty of justice. They claim that I wrongly interpreted the law and wrongly applied the law. I have since then been subjected to constant persecution by the prosecution's office. It is a completely fabricated case, and trumped-up evidence has been sent to the court. There have been lots of deteriorations in the situation of rule of law and the judiciary in Moldova. I have long been critical of the judiciary in my country, in particular the High Council of Magistrates, and the fact that court trials were held not on the basis of the merits of a case, but in light of loyalty to the authorities. I have, as I said, been dismissed from the judiciary, and despite the fact that I was dismissed by a body that was declared unconstitutional by the Constitutional Court itself, my case is still being examined, and there is a lot of foot dragging, and I have not been reinstated. These cases affect not just myself, but other judges. A judge is facing charges because he refused to issue an arrest warrant, for instance. We call on this high forum to monitor the implementation of international standards related to the independence of the judiciary, the separation of powers, and the creation of independent, self-regulating bodies within the judiciary, and to prevent political meddling in court rulings and decisions handed down by judges. Thank you. I will hand in my full text to the Secretariat. Thank you. I just wanted to clarify, were you speaking as in the capacity of Freedom Now? I have been invited to speak as the Global Ukraine Foundation.
To give the floor to Freedom Now, followed by Hungarian Helsinki Committee. Freedom Now, the floor is yours.
Thank you. An inherent desire for fairness and equality runs through humanity, and it is in stable and transparent institutions that we thrive with dignity. As defined by the OSCE, the rule of law is not mere formality. It is justice based on the recognition and full acceptance of the supreme value of the human personality and guaranteed by institutions providing a framework for its fullest expression. OSCE states all profess to uphold rule of law, parroting international law and proclamations by multinational institutions. But genuine respect for rule of law is far from universal. There are gaps and failures in all states, and for individuals wronged and for the health of society at large, we must all work to address these deficiencies. But it is the purposeful misuse, the intentional abuse of judicial systems by governments in the OSCE and OSCE states that causes the greatest harm and is in need of the most urgent attention. In Azerbaijan, the government has purposefully used its laws and its courts to pursue a political agenda of eliminating critics and opponents. While the government claims these are legitimate arrests and detentions, legal scholars disagree after reviewing the charges against civil society members and the performance of the courts. Officials do little to hide their political motivations, often making public statements identifying individuals as being against the state. And while many of those detained are released early, other individuals take their place through the country's revolving door, the country's jail's revolving door. And for those released, they continue to face harassment and unfair restrictions, such as travel bans. While journalist Khadija Ismailova's mother was laying dying in Turkey, officials refused her request to travel so that she could see her mother's last moments on earth. If an independent judiciary is the cornerstone of rule of law, then an independent legal profession is the catalyst that helps achieve it. Yet in Tajikistan, lawyers are subjected to imprisonment, intimidation, and death threats. Two lawyers, Bazargumar Yurov and Nuridin Makamov, are serving prison sentences of 28 and 21 years because they acted as lawyers for political opposition leaders. Furthermore, the government has taken steps to curtail the independence of lawyers. Since 2015, the law requires all lawyers to renew their licenses with the Justice Ministry as opposed to an independent bar association. Such a move and a requirement has reduced the number of lawyers in the country by 50%. We call on all OSCE members to view such systematic abuse of the judiciary and the legal profession as an inexcusable derogation of international obligations. The targeting of lawyers goes well beyond political persecution. It obliterates any opportunity of fairness. OSCE members must take action to protect rule of law and help combat assaults against it. Thank you.
Thank you very much indeed. I would like to pass the floor now to Hungarian Helsinki Committee, followed by crude accountability.
Thank you. Your Excellencies, dear colleagues, the Hungarian Helsinki Committee believes that an independent and effective judiciary is vital in a democratic state. While the judiciary shall be accountable to the society, the role of the judiciary is not to protect the interest of the majority, but oftentimes to protect the rights of the individual, even against the majority or against the state or its executive branch. Today, this principle is at stake in Hungary. The Hungarian Helsinki Committee wishes to draw your attention to growing numbers of recent attacks against judges and the independence of the judiciary in Hungary. With no prior consultation and merely 3 weeks after the bills were proposed, thus violating the principle of democratic lawmaking, the Hungarian Parliament adopted the 7th Amendment to the Fundamental Law this June. Given the present collapse of the legislature into an overpowering executive, incremental changes to the judicial organization are now snowballing into a real and serious threat to the rule of law. The latest constitutional amendments further blurs the boundaries between the executive power and the judicial power and expands government control over the courts. The 7th Amendment to the Fundamental Law undermines the separation of powers and limits the freedom of judges to interpret the law. Under the new provisions, the starting point in interpreting the law will have to be the reasoning attached to a legislative proposal, which is oftentimes not more than the political statement of the governing majority. The 7th Amendment splits the court system into two and sets up special administrative court system, which is likely to be led by a political appointee selected by the parliament. Thus, important cases of public administration, including elections, taxes, public procurement, and freedom of assembly, complaints against the police action, and even freedom of information cases, among many other key civil liberties issues, will be dealt by this special court system. After months of aggressive campaigns against civil society and the political opposition, senior politicians and government's media machinery began to discredit individual judges. Therefore, we call on the OSCE and OSCE participating states to continue monitor the situation of judges and the independence of the judiciary in Hungary and support judicial self-administration bodies, as well as members of the judiciary who face public shaming for publicly criticizing interference into the independence of the judiciary. We urge the government of Hungary to fully comply to its human dimension commitments, including the 91 Moscow document, as well as to fully implement the OSCE ODIHR 2010 Kiev recommendation on the independence of the judiciary. We call on the OSCE to engage with the government of Hungary to encourage meaningful dialogue between the government, all affected parties within the judiciary, legal professionals, as well as civil society in order to ensure that institution building, development and other programs are human rights compliant. A full written statement is distributed through a document management system. Thank you for your attention.
Thank you very much indeed. I would like to give the floor now to crude accountability, followed by rights and freedoms of Turkmenistan citizens.
Thank you very much. My name is Kate Waters. I'm Executive Director of Crude Accountability and a founding member of the Proof They Are Alive campaign. My remarks this morning are focused on the absence of fair trials in Turkmenistan, which has contributed to the horrific and illegal practice of enforced disappearance. Over 100 individuals have disappeared in Turkmenistan's prison system since 2002. These individuals, to a person, were tried in unfair trials without access to adequate legal counsel and on trumped-up charges. Since their trials, they have not seen their family members or had access to legal counsel, medical care, or been able to receive packages. Of these individuals, 60 were charged in relation to the alleged coup attempt on then-President Niyazov in November 2002. Convicted in a Stalinesque show trial, they are serving sentences in complete isolation. At least 9 of these individuals have died in custody. Also denied fair trials are 30 individuals, also disappeared, accused of Islamic extremism. 4 of them have died in prison. 26 individuals on the list of the disappeared were accused of economic crimes and abuse of power. Victims of a Stalin-style purge, they found themselves out of the good graces of the president and were sentenced to long terms. 13 are confirmed dead. The proof list also includes 3 members of civil society who were wrongly accused, tried, and sentenced unfairly by the Turkmen regime. Journalist Ogulsapar Muradova was arrested, tried, and imprisoned, and died in prison in 2006. In April of this year, the UN Human Rights Committee found the government of Turkmenistan responsible for violation of her rights, including the right to a fair trial, and called upon the government to conduct an impartial investigation into Muradova's case and to provide full redress to her family members, including rehabilitation of her name. Gulgeldi Ananiyazov has been in prison since 2008. Since September 2015, the authorities have publicly stated he's being held in a regular colony and allowed visits, but no one has been able to see him. Almrazak Omar Kaliyev, who established a Turkmen student association in Turkey, was lured into Turkmenistan in February 2018 when the authorities invited him to participate in a preparatory event for the upcoming parliamentary elections and then prevented him from exiting the country. Soon after he appealed to foreign media, he was arrested and sentenced in a closed trial to 20 years on trumped-up charges. The absence of an independent judiciary and the failure to hold fair trials has significantly contributed to the inhumane and illegal practice of enforced disappearance in Turkmenistan and must be stopped immediately. We call on the government of Turkmenistan to immediately halt this abhorrent practice and on international governments and members of the OSCE to hold Turkmenistan to account for its flagrant violations of its international human rights commitments. Thank you.
Thank you very much. I would like to pass the floor now to rights and freedoms of Turkmenistan citizens, followed by movement of renaissance of the Northern Epirus.
Спасибо. Thank you. The officials in Turkmenistan constantly try to account for the international principles at OSCE meetings, but in actuality, we have the rule of law in my country, but we don't have the rule of rights. This is why politically motivated trials and show trials are standard and norm in Turkmenistan. Someone who his rights have been trampled, and if someone is abducted, they have no recourse. In practice, in 2018, over 100 people who have the so-called case of attacking Niyazov have not been found, as well as other crimes. Also, a number of managers, after they were fired, were arrested, after which they completely disappeared. This practice continues up to today. violence, abductions, it is the head of the country that should be responsible for this. It is the president who is the guarantor of the Constitution, and it is the president who should be responsible for the implementation of law. Pre-trial verdicts of guilty have been commonplaces. In other words, when a trial starts, the accused already comes shaved in shackles, and they stand trial in this manner. The Constitution says that people have the right to free movement, but in practice, many people are on lists of people who have no right to leave the country, and those who have left Turkmenistan no longer have the right to come back to the country. As a recommendation, we would like to say that the violent disappearances practice should be done away with. We should have the right for people to have free trials, to put an end to torture and illegal detention with the aim of giving forced evidence, and to put an end to hushing up the truth about the lives of people who have already been disappeared, as well as the right for people to free move in and out of Turkmenistan. Thank you.
My list is Movement for the Renaissance of the Northern Epirus, followed by Paris Bar Association.
Thank you. As a representative of the Greek national minority in Albania, our recommendation is simple. All court decisions must be respected by governments, regardless of whether they are in favor or against their official position. Judges must be impartial, and governments must not put pressure on them to violate human rights using the vague notion of national security as an excuse. The members of the Greek national minority in Albania face serious problems with Albanian justice regarding especially the properties issues. A characteristic example is the case of the village of Kostari in the municipality of Finiki. The Committee for the Return of Properties after the communist regime had illegally granted 136 hectares of grassland forest land which belonged to the villages of Kostari to non-beneficiaries. The people of Kostari challenged the decision, and a 5-year legal marathon began with endless court proceedings and postponements. There were continuous changes of the judges who were chosen every time by the encroachers themselves and their political patrons, something that the people of Kostari repeatedly denounced. But finally, on January 17, 2018, the Court of First Instance ruled against the Greek villagers, making the Greek minority lose faith once again on the Albanian legal system. Once again, the intransigence of the Albanian state and justice has been confirmed. They make it crystal clear that they will not take a step back regarding the properties issue of the Greek national minority, even when there are undisputable proofs of counterfighting. We should also never forget the murder of Aristotelis Goumas on August 12, 2010 in Himara by Albanians simply because he was speaking in his native Greek language in his own homeland. The Albanian justice set the accessories to the murder free and sentenced the driver who ran over Aristotelis Goumas twice to just 12 years imprisonment. We have reasons to believe that he's not even in jail, as his whereabouts are unknown. It should be noted that the victim's family was not called to the court and was not officially informed of the decision. They learned that there had even been a trial by a journalist who asked them what their thoughts were on the decision. There are, however, cases where the government does not respect those court decisions they don't like. On October 31st, 2017, the Albanian Prime Minister Edi Rama decided to proceed with the demolition of houses belonging to Greeks of Himara, despite the fact that the administrative court had ordered for the demolitions to stop. Thank you.
Thank you very much. I would like to give the floor now to Paris Bar Association, followed by International Humanist and Ethical Union.
Lawyers play a fundamental role with regard to access to justice and to the law. It is considered, with regard to the basic law of the United Nations, as an essential agent of the administration of justice. Confidentiality, independence, freedom of expression, and a clear distinction between the lawyer and his client or the cause he defends. These are the fundamental principles which must guide the profession of lawyer, and which unfortunately are not always applied in all countries of the OSCE. The most threatened lawyers are the ones who defend cases that we consider to be sensitive ones, for example, defending bloggers and journalists, the cases of expropriation, the defense of human rights defenders, politicians, union workers, or those who have been victims of torture by the state. Often they are physically threatened to be put in jail, to be kidnapped, be placed in psychiatric hospitals, or being killed. Often they are victims of more subtle retaliation systems, disciplinary measures, and their permanent threat of being debarred. In certain countries, lawyers can be brought at any time before a professional verification body, which is a real measure of censorship. Common law is important. Sometimes these are also violated. They are threatened with, for example, fiscal or administrative crimes. Those who deal with very sensitive cases can also sometimes lose potential clients and are under great economic pressure. Sometimes the communication between the client and the customer and the lawyer and the client are also violated. In 2018, we focused on the case of Egyptian lawyers. In December of 2019, we will focus on Turkish lawyers, which are also under an enormous threat right now, where 118 lawyers were arrested. The Paris Bar Association created a registry of lawyers in danger in order to provide assistance to threatened lawyers throughout the world. The Paris Bar Association calls upon the OSCE participating states to ensure that the basic principles with regard to the role of lawyers should be defended and to ensure the independence of lawyers. For all of this is important in order to play an important role in protecting lawyers as a group and individually. Thank you.
Thank you very much indeed. I would like to give the floor now to International Humanist and Ethical Union, followed by International Bar Association's Human Rights Institute.
Thank you, Mr. Moderator. The democratic principle that human communities should have the ability to freely choose how they are governed and by whom, and have mechanisms to hold to account, recall, and change their governments, is grounded upon valuing the full development and equality of each individual and their need for freedom and security. As the concept note accompanying this session observes, OSCE commitments on democracy reaffirm this, stating that citizens should have a meaningful opportunity to participate in the legislative process, with special attention to be paid to ensuring the effective participation of minorities and marginalized groups. Whilst the human rights to self-determination, freedom and security give rise to the need for democracy, paradoxically, we also see the democratic system itself and the will of the people being used to undermine the participative rights of marginalized individuals. The denial of equality and rights for all citizens, regardless of their sexual orientation or gender identity, is often defended on the grounds that such denial represents the democratic will of the people, that equality for all is not supported by consensus at home. Indeed, even in this forum, the need for consensus takes precedence over recognizing equality for all. This sort of reasoning was highlighted by Pope Francis and quoted by the Holy See representative during the opening remarks of this year's meeting, where, and I quote, "Debatable notions of human rights have been advanced that are at odds with the culture of many countries, and such countries feel that they are not respected in their social and cultural traditions," unquote. However, we put it to you that when it comes to protecting all individuals seeking to participate as equal democratic citizens in any OSCE participating states, consensus and democracy cannot trump the human right to equality under the law. Last year, in its Minsk Declaration, the OSCE Parliamentary Assembly stressed the vital role of tolerance, understanding and cooperation, specifically for LGBT persons, in achieving and preserving stable democratic societies. We urge the OSCE participating states to do the same here in Warsaw. Democratically made decisions never justify freedom and security being for some citizens only, for democracy relies on every individual being equal under the law. Take that away and you erode the values that underpin any meaningful democratic system. I thank you for your attention.
Thank you very much, and thank you for observing time limit. Now I'd like to give the floor to International Bar Association's Human Rights Institute, followed by Freedom House.
Thank you. The independence of the legal profession is essential in ensuring respect for rule of law, fair trial guarantees, and protecting a democratic society. Lawyers must be free to discharge their duties without undue interference and pressures from the state. The International Bar Association's Human Rights Institute calls upon the OSCE and its participating states to urge the government of Azerbaijan to end the harassment of the independent lawyers working on human rights cases and ensure they can fully perform their professional duties. We are particularly concerned about the ongoing disbarment of human rights lawyers, which effectively precludes them from continuing their legal work and leaves victims with no real legal aid. Last year, Yelchin Imanov was disbarred for raising the issue of torture of his imprisoned client. Lawyers Nemet Kerimli's license was suspended because of the critical statement he made to the media concerning the case he was working on. Just a week ago, on the 5th of September, the Azerbaijani prosecution addressed the Azerbaijani Bar Association with a request to consider the license of lawyer Elchin Sadigov after secretly tapping his and his detained client's conversation and trying to use this against him. We note that the confidentiality of the lawyer-client relationship is a crucial principle of the independence of lawyers and the right to fair trial. The Azerbaijani authorities are not even hiding they violated this principle, as they publicly use the confidential communication between the lawyer and the client to try to prove the case against lawyer Elchin Sadigov. We urge Azerbaijan to respect the independence of lawyers, the UN basic principles on the role of lawyers, as well as the European Convention of Human Rights, and drop the case against Elchin Sadigov immediately. Finally, we also urge the government of Tajikistan to ensure the independence of lawyers in Tajikistan by amending the law on bar associations, by removing the Ministry of Justice representatives from the Qualification Commission. The Ministry of Justice must give up its current undue influence over the Qualification Commission, which is responsible for licensing lawyers, as this has led to a dramatic drop in the number of lawyers in the country, and these developments impede the state's ability to ensure access to justice for all. Thank you.
Thank you very much. Next on my list is Freedom House, followed by Alga.
Thank you. Freedom House is gravely concerned by the recently apparent systematic crackdown on the legal profession by a number of OSCE participating states, especially Azerbaijan, Tajikistan, and Kazakhstan. The intense persecution of the legal profession undermines individuals' essential right of equal access to justice. In Azerbaijan, the National Parliament amended legislation to state that only members of the Azerbaijan Collegium of Advocates can represent clients in court, thus substantially cutting the proportion of lawyers to the population to one of the lowest rates in the OSCE region. At least 10 lawyers, including Khalid Bagirov, Aslan Ismailov, Alaif Hassanov, and others, have had their bar membership suspended or revoked shortly after they raised human rights concerns on behalf of their clients. In Tajikistan, police have continued to systematically arrest lawyers representing the Islamic Renaissance Party of Tajikistan, who are routinely charged with extremism or corruption after taking cases related to the RPT. Lawyer Buzurgmer Yorov was sentenced to over 20 years in prison. Yorov's brother, sister, and lawyer were also arrested. Lawyer Kadyrova, who agreed to provide legal defense to Yorov, was forced to flee country or face charges. In Kazakhstan, the government revoked the licenses of lawyers who spoke out against the law that gave the Ministry of Justice significant power in disciplining lawyers. Similar to Tajikistan, it has persecuted lawyers of banned organizations like Botagozher Demalid, who advised the exiled leader of the movement Democratic Choice of Kazakhstan. Bogus charges are also used to harass lawyers. For example, advocate Baurzan Azanov was charged with dissemination of false information and accused of undermining the trust of the public in the law enforcement after he became a pro bono advocate for a child rape victim and regularly highlighted his legal work on the case. Freedom House urges the OSCE to hold the responsible governments accountable for the systematic harassment of lawyers, and in particular to utilize trial monitoring as a tool to strengthen fair trial and access to justice guarantees, and encourage participating states to implement reforms based on rule of law. Freedom House calls on the governments of Azerbaijan, Tajikistan, Kazakhstan, as well as other states that are considering or implementing statutory and punitive restrictions on the legal profession to immediately cease prosecution and fully restore the constitutional and professional rights of lawyers persecuted or convicted on spurious charges and through faulty adjudication processes because of their work with human rights defenders, journalists, civic or political actors critical of the government. Thank you.
Thank you very much for those important recommendations. Now I would like to give the floor to Alga, followed by delegation of Canada.
Здравствуйте.
Good morning, ladies and gentlemen, and dear participants. I represent the Republic of Pakistan, and we have sent more than 20 letters to the President of Uzbekistan concerning violations of the judiciary, unlawful arrests, and abuses by the law enforcement authorities of Uzbekistan, but we have received no answer, and the lack of rule of law is ongoing. However, despite the fact that we drew attention to all these human rights violations, we have also been forced to see that cases of genocide have taken place. We cannot call things by any other name in Uzbekistan. I am here to appeal for the OSCE's help and for the UN's help to exercise pressure on Uzbekistan. We need to sit around a negotiating table and begin a dialogue. The authorities of Uzbekistan must tell us what they want from the Republic of Karakalpakstan. I believe that the representatives from both governments, Uzbekistan and Karakalpakstan, should be transparent and honest, and they should take place in the framework of international law and standards. I am prepared to cooperate with whoever is willing to work on this through dialogue, through peaceful dialogue. Karakalpakstan is not Uzbekistan. Karakalpakstan is a parliamentary republic. Uzbekistan is a republic ruled by a presidential rule. And we, however, are open to constructive dialogue. The OSCE is the most reliable and trustworthy place for such dialogue. The authorities must tell us what they expect of us in an honest way. We are prepared to discuss all conditions. I have faith that the President of Uzbekistan will withdraw troops from the Republic of Karakalpakstan. The Republic of Karakalpakstan, with the assistance of the OSCE, can hold free elections without interference by Uzbekistan. Unfortunately, the Parliamentary Republic of Karakalpakstan currently has no official party. It is, on the contrary, manned by parliamentarians from Uzbekistan.
I would like to give the floor to the delegation of Canada. Ambassador, please.
Thank you, moderator. We wish to offer the following recommendations to the OSCE and participating states with regard to the rule of law. Number one, that the OSCE and its participating states reinforce international mechanisms and standards that prevent the violation of rule of law in our region, and that participating states assiduously uphold their existing obligations and commitments to the principles of fair trial and judicial independence. Secondly, that both violations of and progress related to the rule of law be monitored more closely by ODIHR with the support of civil society and other appropriate international organizations, and that reports of these issues be made on a periodic basis. Thirdly, that the OSCE and ODIHR give further technical assistance to participating states that are trying to enact positive reform to their judicial systems to further strengthen their democracies and better protect the rights of their citizens. Moderator, OSCE participating states in Copenhagen in 1990 recognized that pluralistic democracy and rule of law are essential for ensuring respect for all human rights and fundamental freedoms. Legislative transparency, the independence of the judiciary, and the right to a fair trial are necessary to ensure that all other human rights and fundamental freedoms can be respected within a society. The violation of basic rule of law principles within the OSCE region is an important indicator of the weakness of a democracy and should be taken very seriously by all participating states. The implementation of equitable laws and justice sector reforms are a foundation for the protection of human rights and enable all citizens to realize their potential by providing an accessible, practical, and effective legal and judicial system. Access to justice must be universal, and the political and power context of a state must not favor any individual or group over another. Moderator, we share the concerns raised by the introducers, the European Union and the United States with regard to the increasing number of violations in the OSCE region, including unjustified arrests and enforced disappearances of political opponents, members of civil society, and journalists simply for exercising their rights, violations of the right of fair trial, and an increasing lack of transparency of the judicial and legislative processes, most troublingly in the area of judicial independence, where several governments are undermining the independence and legitimacy of a key component of democracy for political ends. Thank you, Mr. Moderator.
Thank you, Ambassador, for reminding us what is the topic of the session. Thank you for observing the time and for your very constructive recommendations. Much appreciated. I would like to give the floor now to Open Dialogue Foundation, followed by Tajik Culture Center.
Thank you, Moderator. As a human rights organization that monitors the situation in the post-Soviet region, I would like to focus on the case of Moldova, which is one of the most relevant examples of the politicization of judiciary. Especially an extremely worrying decision was recently made by the Supreme Court to nullify the legitimate voice of the citizens in the Chisinau mayoral elections in a non-transparent way, which shows that the independence of judiciary in the country is undermined by political interference and that courts in the country are under the control of a political elite. Examples of such undue influence on the independence of judiciary are those of persecuted judges such as Dominica Manole, Gheorghe Balan, and Dorin Munteanu, who are all subjected to persecution for their independent decisions and for criticizing the system. Dominica Manole, as a judge of the Appellate Court of Chisinau, was persecuted as a consequence of her independent decision to uphold the citizens' initiative to hold the referendum and her refusal to bow under political pressure. Judge Balan was subjected to persecution as a consequence of his harshly criticizing the political influence of the judicial system. And Judge Munteanu was persecuted after his refusal to issue a politically motivated warrant against lawyer Anur Saki. This also is an indicative factor of the fact that the independence of lawyers is at stake as well. As concerns the right to have an attorney chosen by the defendant, which is a prerogative to the fair trial, the Foundation remarked that such right was infringed in the case of persecuted attorney Anur Saki, for whom the court issued a warrant of arrest without her lawyers being present. Using the state lawyer and ignoring the defendant's claim against the use of such lawyer who was not in the capacity to defend her properly. Her case is also an example of a breach of the principle of presumption of innocence, which was breached as a result of numerous smear campaigns launched by mass media controlled by oligarchic power. The Foundation has monitored a worrying decreasing trend in other countries of the post-Soviet region, such as Azerbaijan, Kazakhstan, and Russia, in the independence of lawyers and judiciary, especially related to those professionals who defend individuals that are persecuted for political reasons and find themselves in danger. We call on OSCE and its member states to act towards a guarantee of the right to be defended, but also to the right to defend, preventing and punishing any undue political interference in the judicial system. Thank you.
Thank you very much indeed. I would like to give the floor now to Tajik Culture Center, followed by public organization Crimea SOS.
Distinguished Chairman, Distinguished Secretary General, ladies and gentlemen. At the outset, I would like to express my gratitude to the organizers of this event of the OSCE in giving the floor to the civil society with regard to the human rights situation on the OSCE space and to improve the situation with regard to human rights as a whole. The outcomes of today's meetings will help us to look in the near future with regard to building societies based on hope. You will see that we need to make sure that people, in order to live together, need to agree with regard to human rights. We hope that all of our creative forces in society will be guided by economic stability and social cohesion. The processes of the implementation of state policies mean that it is the youth must be accountable for the future. Our country includes 130 ethnic groups. The Kazakhstani society ethnically is very varied. The Constitution of Kazakhstan guarantees the development of all people and citizens with regard to equal opportunities for life and work. Kazakhstan focuses on the national policies in order to ensure a proper level of development and quality of life. Next year, we're going to have new policies with regard to our national policy. The Assembly of the Peoples of Kazakhstan, the chair of which is the president, Mr. Nazarbayev. Today, in Kazakhstan, the international organizations have noted the progress we have made in our country. We have 96 national cultural centers as well as other centers that focus on the prosperity of ethnic groups. We also have a diaspora of Tajik peoples who live in Kazakhstan. Asylums and refugees during the Civil War period in the beginning of the 1990s, the friendly people of Kazakhstan took in many asylum seekers and refugees during the Civil War.
If you could conclude, please, 10 seconds.
Today, many diaspora are under threat. Over the past 3 years, labor migrants were victims of the Party of Islamic Renaissance. Thank you.
And I would encourage you to submit your statement to the Documentation Center. And now I would like to give the floor to public organization Crimea SOS, followed by Fund for the Legal Support and Protection of Compatriot Living Abroad. The public organization Crimea SOS, the floor is yours.
Good morning, colleagues. About 95 people during the Crimean accession period have become victims due to ethnic and religious signs. Many of these people were found guilty. 23 were linked to jail time. Over 320 politically motivated court decisions were handed down. Such practice is broadly used as using secret witnesses, falsification of experts, and also breaching the procedural rights of lawyers. Sometimes before the court starts their discussion, the guilty verdict is drafted ahead of time. Often we have heard that torture was used in order to obtain false evidence. In the practice of using secret witnesses in Crimea means that the defendants have to deal with witnesses who are hidden and are in a different room. In that way, no one has visual contact with witnesses. And sometimes lawyers say that one gets the impression that other people are coaching the witnesses behind closed doors. Another case is the case of Nikolai Simini, where he was found guilty based on fabricated experts' evidence, where there were 72 mistakes. Quite often, the courts close the doors of the trials to the public and ban video and cameras in the room. This was the case against the Crimean Tatars. Sometimes those who are accused of political crimes are held in pretrial detention, which is unjustifiable. Also, the right to fair trial is often violated. The witnesses are often from the law enforcement agencies themselves who give false testimony, and they use quite often falsified documents in court. Thank you.
Floor now to Fund for Legal Support, followed by All Ukrainian European Foundation, the League of Law.
Distinguished moderator, distinguished colleagues. Mr. Zanier, the High Commissioner of the OSCE on National Minorities, noted the statements which say that minorities pose a threat to security as a group which is vulnerable to the ideology of violent extremism risks boosting nationalist attitudes amongst the majority of society and also promote internal pressures and tensions against ethnic groups. Hate rhetoric leads to a discord and breaks up society. We have seen very often in the Baltic states when worrying about Russian-speaking diaspora has been the responsibility of their security. This means that the Russian-speaking minorities, which in Latvia make up of over 1/3 of the population, are represented as the main threat to the country's security. Where is this threat? For example, the main threat to security of Estonia, according to a report for 2017, is Russia's concern for the Russian-speaking minority and towards the youth. One clear expression of this threat is the participation of Russian-speaking youth in such threatening events in Estonia, as, for example, the 2017 Global Festival of Young People in Sochi, where in addition to Russian-speaking Estonians, 20,000 young people from 180 countries of the world participated. The Estonian International Security Service Annual Review from 2017 on page 5. That's where I quoted from. Blatantly glaring statement from the Lithuanian State Security Department says that it is only even the schools of national minorities pose a threat to national security. And they usually use intimidation, search, and arrest. On the 20th of April, the co-chair of the Congress of Russian Communities in Latvia, Mr. Gaponenko, was arrested by the Latvian security police. As the activist said, he was the victim of physical and psychological pressure. He was beat up, he had to fall on the floor, and was in handcuffs for 11 hours. The Latvian activist, Mr. Gaponenko in Riga, is also a victim of intimidation. All Russian speakers in Latvia, especially those who support and endorse the right to Russian education in the country, we believe as this is an attempt to violate the right of expression. It's unacceptable.
The floor to the next speaker. Thank you. As we are approaching the speaker number 25, we're in the middle of our speaker list. I would just like to make 2 remarks. First of all, please do not abuse the moderator as a very gentle and kind person and stay on the topic, because I will have to interrupt those who are off the topic. And second thing is we have to restrict the time, and we have a clear number of speakers, so I would like to ask everyone to collaborate with me to make sure that this session finishes on time. And I would like to give the floor now to All Ukraine European Foundation, the League of Law.
Thank you, Mr. Moderator. I represent the Ukrainian human rights organization, the League of Law. We have been closely monitoring the developments in the area of reforms of law enforcement authorities and judiciary for the last 3 years. Every year we speak about numbers of violations in the number of criminal justice in Ukraine. But numbers are just statistics. Nobody takes it personally. This year is different. I'm going to speak about one particular case where a person is simply failed by the state of Ukraine and its law enforcement authorities, and no action has yet been taken to restore the justice and fix the major prosecution and judicial errors. The person I'm referring to is Ivan Sherstyuk, a Ukrainian human rights defender, patriot, and civic activist, co-founder of few non-profit foundations. Ironically enough, he was sitting at the very same table on annual Human Dimension implementation meeting in Warsaw 8 years ago, speaking about human rights violations in the post-Soviet countries. However, since then, Ivan has been persecuted by the Ukrainian law enforcement authorities, accusing him of the most ridiculous crimes, starting from hooliganism and ending with preparation of murder organization. As soon as the previous accusation had fallen apart, the new one started. Ivan has been in custody without a final decision since 2012, almost 6 years. Ladies and gentlemen, I'm asking you to think for a moment about this term. 6 years in pretrial detention in democratic Ukraine without final court decision on his guilt or innocence. Staying for such a long time in the Ukrainian pretrial custody is considered as a torture, as well inhuman and degrading treatment by most well-respected human rights organizations and the European Court of Human Rights. At least 5 times, Ivan's arrest was prolonged without his or his lawyer's presence, basically making the trial declarative. The court proceedings have been constantly cancelled or postponed, while Ivan was held in prison. However, to be able to appeal these violations, one needs to have the final court verdict, and Ivan Sherstyuk has not been provided one. These are the major violations of the right to a fair trial within reasonable time by the impartial judge, and nobody has been brought to justice for this. Therefore, we urge the Ukrainian law enforcement authorities and judiciary to stop the office abuse and ensure the right of Ivan Shestuk as well as other illegally accused to a fair trial within a reasonable time and freedom from illegal criminal prosecution and imprisonment. Also, we urge OSCE state members to monitor the developments in Ivan Shestuk case and express the concern regarding the respecting human rights violations. Ivan Shestuk has been defending human rights all his adult life. However, now he needs others to defend his before it is too late.
Thank you very much for your remarks. Now I would like to give a floor to the next speaker on the list. It's Turkmenistan Helsinki Foundation for Human Rights, followed by Salut at Misericordia.
Ladies and gentlemen, following what my colleague said on Turkmenistan, I would just like to make a few recommendations. As you know, in recent years, the OSCE has started carrying out seminars and training sessions for law enforcement bodies, and I would like to draw the attention to the following. In Turkmenistan, the prosecutor's office has, instead of being a supervisory body, is a punitive body. In terms of lawyers, I have to say that most lawyers in Turkmenistan are under the authorities' control. Not only are they not free in their actions, but they are often at the service of the prosecution instead of the defense when they're defending an accused. Lawyers might need to be brought to account for their lack of professionalism. Also, evidence is admitted in breach of the Constitution when it is submitted by the police, for instance. And there are also cases of confessions which are used to not to lighten sentences, but on the contrary, to worsen the charges. Article 23, Part 1, provides the courts of first instance a punitive role which goes counter to the adversarial principle. Also, Article 362 and Article 363 of the Criminal Code of Turkmenistan stipulates that courts have the right to bring criminal charges in a format which is tantamount to criminal investigation and harassment. Also, often a court of jurors is used in cases when it wouldn't be elsewhere. Thank you.
For your recommendations, I would like to give a floor now to Salut at Misericordia, followed by Commission of Protection of Illegal Accused.
Thank you. I am speaking on behalf of the
At Misericordia, followed by Commission of Protection of Illegal Accused. Please, Salut at Misericordia, the floor is yours.
Monsieur le modérateur.
Mr. Moderator, ambassadors, distinguished colleagues, I would like to talk about an issue that is not politically correct. I'm going to talk about the presence of Islam in the EU. Islam, which is tantamount to Sharia law, presented as a divine law itself, that is to say, a law that is contrary to any law devised by human reason in light of divine law. That is why in 2003, the European Courts of Human Rights in the Refa Partisi case declared Sharia as being incompatible with and contrary to the basic principles of democracy and the values of the European Convention on Human Rights. The court also condemned the multi-jurisdictional system and the coexistence of various legislations which can be found in Sharia law and which gives Sharia law legal competencies or jurisdictional competencies, because this law basically divides people into pure and impure depending on whether they abide by Sharia law or not, and it may ignores the equality of rights of all before the law. Islam makes no distinction between the political realm and the religious realm. Thus, it is a totalitarian political project. I am therefore very surprised that the European Union and its member states should actually foster the entrenchment in Europe of Islam through mosques and Islamic centers which teach Sharia law. This can be seen, for instance, in the President Macron's plan to build a French-style Islam. Now, not only does the French Constitution prohibit the state from meddling in religion, but Allah prohibits Muslims from submitting to non-Muslims. So this project is doomed from the very beginning. All it can do is further entrench Islam in France by giving it a cloak of legitimacy and respectability that it could not possibly acquire otherwise. And all this at the cost of the taxpayer. So, Mr. Moderator, I would like to ask the ODIHR to remind European states of this and to ask them to reform their legislation in order to take account of incompatibility of Sharia law with human rights.
Give a floor to Commission of Protection of the Illegal Accused, followed by Information Group of Crimes Against the Persons. And I do apologize, we really have to observe time.
I am speaking for the Commission of Protection of the Legally Accused, and there are. I would like to say that the stability of court decisions is one of the main principles of the judiciary. However, sometimes a judge, when they take a decision, do not know all the circumstances which are relevant, and it is very difficult to revisit a decision in light of new evidence. I would make a number of recommendations. We need to create clear grounds for reviewing court decisions, and we must also create a procedure for doing so, and consider giving judges power to review decisions in light of new evidence. These shortcomings can be amended by changes to the legislation. Between 2001 and 2011, rulings in cases of crimes punishable by life imprisonment were examined by a court of appeal in the capacity of a court of first instance, and it comprised a jury trial. 1,400 people were sentenced by a court of appeals, which was acting as a court of first instance between 2001 and 2011, but we have had no news as to whether any of them have been released following reversals of the decisions. Sometimes district courts do not have the authority to review or reverse decisions handed down by courts of appeal, and this is problematic. There is no procedure for reviewing cases in such circumstances. District courts either refuse to review a court of appeal, or because they often amount to the very same court of appeal, the two are one, they simply uphold the original ruling. The Criminal Code of Ukraine, in Article 375, can hold court judges liable for their decisions. But I would say that the Ukrainian term travesty of justice is biased, and it should be replaced by a different term, such as an unlawful or unfounded decision. But we cannot revoke the article simply because that could lead to arbitrary decisions.
To the distribution center. And I would like to ask everyone, please keep in mind that we have hard-working translators who have to follow those of us who speak fast, including myself. So slow down, please. The next person on the list would be Information Group of Crimes Against the Persons, followed by International Partnership for Human Rights.
Good morning. The situation of the rule of law in Ukraine is extremely alarming, according to our organization. First of all, as we know, in Ukraine there is basically no independence of the judiciary. The Public Prosecution Office and the other law enforcement bodies basically dictate rulings, in particular under Article 375. The Public Prosecution's Office of Ukraine filed 670-odd cases against judges in Ukraine last year. Also, there are glaring offences and crimes that have been committed in Ukraine since 2014, and many of them have not been investigated. For instance, the killings on Maidan have still not been investigated. This took place in November, between November and 2013 and February 2014. The perpetrators who burnt people in Odessa in May 2014 have still not been brought to account, nor have crimes against or the killers of Pavel Sheremiet and other people have still not been brought to justice. These people were killed in 2014. Thirdly, judges are often accused of separatism, or they are under investigation because of this, and such a situation can last for several years, and it is absolutely horrific. Crimes committed by far-right groups remain unpunished. In the far-right organizations committed multiple crimes in Kiev and Lviv and other places, and there has been no follow-up on this. And finally, a fifth point. In Ukraine, I would like to remind you that there is an entire region that is, and this is the Ukrainian-controlled part of Donbass, where there is a specific regime in place that breaches the rights of all citizens living there. Thank you.
For human rights, followed by Public Foundation Aruk Krak.
Good afternoon. I'm speaking on behalf of the International Partnership for Human Rights, together with Amnesty International, Association for Human Rights in Central Asia, and Uzbekistan-based human rights organization, Restoration of Justice. I would like to start on a positive note by congratulating the government of Uzbekistan with the reforms that are currently underway in the country. President Mirziyoyev has undertaken an ambitious reform program and adopted a national action strategy focusing on judicial reform as one of 5 priority areas. In a welcome move in May, Uzbekistan accepted recommendations at the UN Periodic Review to ratify the optional protocol to the Convention Against Torture. Over the past year, President Mirziyoyev signed legislation prohibiting the use of evidence obtained through torture in court, as well as strengthening punishments for torture. Crucially, the legislation also prohibits law enforcement officials from using torture against relatives of detainees and suspects. Also, this year, at least 10 law enforcement officials were brought to justice in connection with allegations of torture to obtain confessions from detainees. However, regardless of the positive notes, which we are very happy to make, we regret that in practice, national legal mechanisms remain largely inefficient, and that the principles of equality of arms, presumption of innocence, and protection against torture are not always respected in court proceedings. During detention, law enforcement officials continue to use disproportionate force and to disregard procedural rights of detainees, which exacerbate the problem of impunity for human rights offenses. We call on the Uzbekistani authorities to ensure the effective implementation and practice of these necessary reforms, as they will be a decisive test of their commitment to upholding international human rights obligations and to improve the conditions of all citizens in Uzbekistan. We are also concerned that sustainable improvements in the human rights situation in Uzbekistan will not be achieved unless the human rights violations of the past are thoroughly and effectively investigated and those found responsible are held to account in fair proceedings. This includes not only investigations of past torture and ill treatment, but also investigations into the tragic events of Adijan in 2005, when security forces killed hundreds of demonstrators, including women and children. We call on the authorities to prioritize establishing accountability mechanisms for past human rights abuses to allow the country to move forward to a more sustainable future. Thank you.
Thank you very much indeed, and I can also encourage other participants and other speakers to start on a positive note. This would certainly make this session more interesting. Now I would like to give a floor to public foundations, Arkruk Kak, followed by independent human rights protectors.
Thank you for this opportunity to speak at this meeting. At the beginning, our speaker said that in the OSCE area, very hard times have emerged with regard to the rule of law and for rights. For Kazakhstan, this has also been the case for the past 27 years. We suffer from political control. In an authoritarian country such as Kazakhstan, of course, things cannot be different. In this connection, I would like to tell you about some cases that necessitate the strict attention from the international community and the OSCE. We would like to see OSCE observers at these court trials. Right now in Kazakhstan, there are 4 politically motivated trials. We've never had a situation in Kazakhstan where at the same time we would have 4 trials of this type where 2 people are awaiting the beginning of their trials to start. Now, for over 3 months, a trial has been taking place of Mr. Alimbetov. A similar trial is also being waged against Mr. Nazarbayev. They are quite typical in that the criminal proceedings that were linked to one charge, and then it wasn't reviewed, but basically they tried to turn it into a case and a charge of fraud. At the same time, there were no assessments from the judge with regard to the case. I would like to tell you also about the case of Mr. Jamayev, where the courts are also ignoring the rights of the accused. The most important thing is that his right to use his own language in the court. There's no transparency. He's being accused of instigating hate using the website Telegram. Also, there are 2 other cases. The cases being tried supposedly said that the case was confidential. Well, they didn't worry about the case that lawyers didn't have access to the confidential evidence, but the trials have meant that this case has been transferred from one court to the next for months now. Also, I would like to raise the case of Muhtaba Jafish. For 9.5 years now, this has been ongoing. We are so worried by his fate.
Please don't hesitate to submit your statement to the distribution center. Now I would like to give a floor to the next organization on our list, Independent Human Rights Protectors, followed by Political Movement Group 24. And I would like to remind all of us the topic of the session is independence of judiciary, fair trials, and democratic lawmaking. Thank you.
Thank you very much for giving me the floor. My name is Kadira Madevhom, a civil activist and lawyer from Tajikistan that am I protecting 2 of my colleagues. Ladies and gentlemen, the practice of law in Tajikistan has gone far away from the Soviet times, although we do have the presumption of innocence in case our courts and judges' mentality has not changed from Soviet times. The violation of procedural norms in court and the verdicts that are handed down based on evidence is the first evidence which are pressured, which are the results of pressure put on people when they're accused without their lawyers. Now, this evidence is often broadcast in the media. For years now, I have never seen the courts hand down a not guilty verdict, only when Article 22 of the Criminal Code has been used in order to open additional investigation. We are very concerned about certain political cases that I would like to draw the attention of you to with regard to the judicial practice in Tajikistan. Often these trials are deemed to be confidential and secret. The procedural code is being violated with regard to the representation of a lawyer for the accused. Quite often, the accused arrive at court accompanied by the police. At the same time, Article 272 of the Criminal Code has been violated with regard to letting the lawyers and the accused to have access to the evidence records. Often the trials are being fabricated. Once in a while, we have cases of torture. The prosecutors and the judges often violate the constitution itself. The government of Tajikistan should free the political prisoners, especially with regard to those people who have been accused in violation of the constitution. My colleagues, thank you.
If I can ask you to submit the statement to the distribution center. Thank you very much. And I would like to give the floor now to Political Movement Group 24, followed by Association of Central Asian Migrants. And I would like to encourage all of us to stay within the time limit.
Thank you.
Good morning, ladies and gentlemen. My name is Mohamed Madilev. I am the political activist of the Group of 24. The rule of law says that no one can be above the law. This is absolutely not respected in Tajikistan. One example is the fact the constitution has been changed many times in Tajikistan by Amir Malif Rahman and the adoption of a constitutional amendment as the leader of the nation in 2016, which gives Mr. Rahman unlimited power, which places him above the law, and all branches of the government are in his own hands. There are no opposition parties in parliament. The judicial authorities have always been weak, and they very much depend on the executive power. The reason for this is that the system in the country is corrupt, because based on the basic law, all judges are being nominated by the president, and the president, who's also the head of the executive power. Now, judges also have low salaries, and so it can be clearly seen that the judicial system in Tajikistan can never be independent under these conditions. The executive powers basically set the agenda for the judicial powers. This is the reason why there's so many political cases, political prosecutions, and closed trials, as well as the illicit sentencing of political activists for long prison terms. This lawlessness has also led to the victims of human rights defenders and entrepreneurs, as well as bloggers, journalists, scientists, poets, as well as simple citizens who somehow were not happy with the policy in the country. The authorities, the legislative authorities, have also been occupied by Mr. Rakhmonov. In Parliament since 2015, not one single opposition party have had access to Parliament. All amendments to the Constitution since it was adopted and its impact on lawmaking have given more power to one single person in the country. For example, the law on creating the fund of the leader of the nation, which will probably be another...
Don't hesitate to submit your statement. I would like to give the floor now to Association of Central Asian Migrants, followed by the Office of the Commissioner for Human Rights Protection.
Thank you very much, moderator. I am the leader of the Association of Central Asian Migrants. In any state, the independence of the judiciary depends on the rule of law, and where the rule of law and the independence of the judiciary are upheld, human rights are respected. In accordance with the Constitution of Tajikistan, fundamental freedoms and rights are ensured through the judiciary, but the judiciary in Tajikistan has long been a business, and it is monopolized by a single family and by a clique of officials who answer first and foremost to the head of state instead of protecting the judiciary. Any criminal case that is brought before a court always ends in a conviction. And in recent years, there has not been a single fully fledged acquittal. The acquittals that should have been given for cases that result in convictions for slander and other such absurd accusations. Allegations of terrorism and extremism are used, as well as trumped up charges and fabricated evidence in order to put people behind bars. And the ministries and other authorities are all in connivance with this. The officials and their clique always do this, and a recent example is that a civil activist, Mr. Khodorova, was sentenced to 5 years imprisonment because he posted on a social media network a song about the authorities, and the court, instead of protecting them, merely fulfilled the instructions of the president. And this is a blatant case of violations of human rights. In terms of human rights and disregard for the law and for the presumption of innocence, I would urge the Tajikistan's authorities to, first of all, cease all arbitrary arrests and
meet those recommendations. They are very much appreciated. But if you could submit them to the distribution center, apologies,
Thank you
we
very
still
much.
have a number of speakers on the list. Thank you very much. If I can give the floor now to Office of the High Commissioner for Human Rights Protection, followed by Path of Guru Jara.
Thank you very much, Mr. Chairman. I represent the Polish Ombudsman, the Commissioner for Human Rights, who is highly concerned about the observance of the rule of law in Poland, especially with regard to the principle of independence of courts. The situation in Poland has been already described and criticized in many international reports, including Venice Commission reports, OSCE audit opinions, or UN Special Rapporteur on the independence of judges and lawyers, for which the Ombudsman is very grateful. However, the government pays no attention to the international documents, and the situation in Poland has worsened seriously. Not only the Constitutional Tribunal no longer works properly, but in a moment there will be no independent Supreme Court in Poland. Let me draw your attention to some of the recent developments. On 3rd July, the retrospectively lowered retirement age took effect for the Supreme Court judges, affecting 27 out of 72 Supreme Court judges, including the first President of Supreme Court, whose term is determined in the Constitution as 6 years and should end in 2020. Yesterday's decision of the President to prolong mandate only for 5 out of 12 Supreme Court judges without any ground or reasoning clearly illustrates the possible influence of the executive over the judiciary. The National Council for Judiciary under new provisions has been already elected in a politicized, non-transparent procedure. Practical implementation of newly adopted laws also shows that the politicians have gained direct influence on the procedures related to the appointment, promotion, and the discipline of judges. The Ombudsman is afraid that the newly introduced disciplinary procedures will be used against those judges who are of different opinions than the Minister of Justice. We suggest following recommendations for Polish delegation. Immediately stop the nomination procedure in the Supreme Court, or at least suspend them until the decisions of the Court of Justice of the European Union. Start the real discussion on the necessary changes in the judiciary in Poland, and avoid actions and discourse which may discredit the judiciary or undermine its independence, including actions aimed at initiating disciplinary proceedings against those judges who just make use of all procedural possibilities to protect the rule of law. Thank you.
Thank you very much indeed, and I would also like to encourage you to submit your statement to the Documentation Center. Now I would like to give a floor to Path of Guru Jara, followed by delegation of Uzbekistan.
Honored participants, my short statement is addressed to the Czech Republic with recommendations regarding the violation of fair trial proceedings in the case of Yaroslav Dobes, Aka Guru Jara, and Barbara Plaskova. As a human rights lawyer, international lawyer in Prague in the Czech Republic, I am in cooperation with the Czech religious group Path of Guru Jara, especially in the proceedings of their registration and also following the criminal case against their two highest representatives. My recommendations to the Czech Republic in the case of Yaroslav Dobes and Barbara Plaskova are: take immediate effective measures for fulfillment of fair trial guarantees, such as the right to access to the court, the case to be judged by an independent impartial court hearing to be public. This was not the case in the first day of the court hearing. The court hearing was closed to the public. The right to effective defense. The court should without delay decide about cancellation of the arrest warrant as its prolongations against EU jurisprudence and is causing arbitrary detention of Yaroslav Dobes and Barbara Plaskova. They are more than 3 years in detention. Promote and assure between judges respect of the European Convention of Human Rights, judgments of the European Court of Human Rights, and rule of law, respecting democratic principles, and not repeat practices reminding treatment of cases in the communist era. Also to respect the principle of in dubio pro reo, in dubio pro libertate, which is also an element of the fair trial principle. I would like to point out that the first court verdict was raised in 2014, and the year after the High Court of Appeal in Olomouc fully abolished verdict for lack of evidence and procedural errors. 2.5 years later, in January of this year, Judge Perlichova from Regional Court Trial in Zli for the second time convicted and both representatives of the religious group. Now is pending the appeal procedure. I would like to point out that the first hearing of the original Brown branch in Zlin was not in compliance with the OSCE reference manual for monitoring of the above-mentioned aspects: independence and impartiality of the court, right and biased complex evaluation of evidence exclusion, and other coercion. So for this reason, I would like to say that although we have 2.5 minutes to talk, we need a constructive reaction from the respective country, in our case is Czech Republic. Thank you very much.
Thank you very much. Now I would like to give a floor to delegation of Uzbekistan. The floor is yours.
Moderator, distinguished participants, ladies and gentlemen, Uzbekistan is committed to great cooperation with the ODIHR with a view to ensuring mutual understanding of the and implementation of the human dimension in our country. One of the key areas of cooperation is ensuring the rule of law, and this ensures the full, proper development of society as well. In our country, there have been a number of developments aimed at promoting human rights, and we attach special attention to the reform of the judiciary. And this was the starting point for an active dialogue on the rule of law, during which we have been discussing new effective mechanisms for cooperation in the field of human rights and for finding common and effective solutions to the challenges of today. For instance, there needs to be measures taken for timely due process and for ensuring the independence of the judiciary as a means for protecting citizens' rights. Furthermore, the administrative courts have been created, and they have seen more than 900 cases, a fair proportion of which were concerning human rights. The courts have rehabilitated more than 600 people through acquittals, whereas acquittals used to be very, very rare in the jurisprudence. And there have also been multiple sentences which have been handed down that do not involve imprisonment. The representative for the freedom of the media was involved in coverage of this. We also have been working on the technological front, so we have created a database which allows for online monitoring of court proceedings. Anywhere in the world you can follow the work of 12 courts, and this practice will be extended to courts throughout our territory. Moreover, today the world and the OSCE region has a new view of Uzbekistan as an open and developing country. The goal of our state is to make sure that the courts are houses of fairness. But we have received criticism that that is not yet the case, which is why we will continue to work hard on reforms in this field, and I will convey my full statement to the Secretariat. Thank you.
Bewegung Gleiche Möglichkeiten für alle, followed by Konstantin Regional Bar Association.
Всем привет.
Good morning to one and all. I would like to begin by addressing the Uzbek delegation, and in particular, Madam Svetlana Arbazhina. I would say that you are right now in Europe and not in Uzbekistan. I am not in an investigation cell, and I would ask you to refrain from making threats to me because I have already lost all I had to lose, and I am now fearless. Uzbekistan considers itself a democratic state, but it is far from being one. I am Burhan Hassan, and I live in Germany. In 2012, I was forced to leave my country. I was the leader of an organization for disabled persons. The authorities of my countries brought charges against me. I sought help within my country. I didn't turn immediately to international organizations, but I found no help, so I had to leave my country. The delegation of Uzbekistan just spoke about judicial reforms, but every week on YouTube you can see appeals made by the citizens to the president of the country. Why do they turn to the president of the country and not the law? Well, because as you can see, the law is fictional in Uzbekistan. The country creates an image of worthwhile reforms, but it is all just a show. I would like to turn us to international organizations to better monitor the judiciary in Uzbekistan, and then I would like to draw the attention to the non-accreditation of the media that is a problem in Uzbekistan. Thank you.
I would like to give the floor to the next speaker, which would be Constantine Regional Bar Association, followed by Almaty City Bar Association. And I would also like to recognize that delegations have the right to exercise the right of reply. We so far have 9 delegations on this list, so if any other delegation would like to exercise their right, please inform us. And thanks to our interpreters who agreed to stay extra few minutes. We have extra time to finish the session, but we have to be very strict now, and this applies to both you and me as a moderator. Thank you.
Good afternoon, ladies and gentlemen. My name is Shadana Kim. I represent the Kazakhstan Bar Association. Today in Kazakhstan, we have a new law on legal assistance and the work of lawyers. In the period in the drafting and discussion of the draft law, in international organizations and lawyers in Kazakhstan presented recommendations which were totally ignored by the law. The law entered into force in July of 2018, on the 23rd of the month. The comments of experts and their concerns were due to the fact that the laws did not correspond to international standards and the basic principles of law. The Bar Association of Kazakhstan is concerned of a parallel bar association, which is going to be called the State Bar, and the legislative possibilities to impact the work of lawyers. Lawyers of Kazakhstan, as we've heard, often are working in critically difficult conditions, which is why our recommendation is to ensure that the laws on the work of lawyers should be brought into line with international standards with regard to the provision of legal assistance, and to set the independence of the lawyers in the legislation.
Now I'd like to give the floor to delegation of Kazakhstan. No, I'm sorry, Kazakhstan would be the next. No, Almaty City Bar Association. Almaty City Bar Association, followed by delegation of Kazakhstan. Apologies.
Ladies and gentlemen, I would like to add to what my colleague said. My name is Mazan Alieva. I work with the Bar Association in Almaty. The role of lawyers is set down as the dependence of legal experts. And this international document, it also clearly states that intimidation and threats against lawyers is also prohibited. With regards to the new law on legal assistance and lawyers, the Bar Association, in line with Articles 21 and 22 and 23 of the new law, is headed by the Ministry of Justice. This is how the work of lawyers is set down in the new laws. The main means of legal assistance is limited to the fact that this law limits legal assistance to individuals who are not legal experts themselves. In Article 3 of Article 4 of the Constitution of Kazakhstan, it says about the priority of international agreements ratified by Kazakhstan, as well as the Vienna Convention on International Law, says that the government cannot refer to its own internal laws to justify the fact that they are not implementing their commitments. Now, the professional work of lawyers in trying to fight the head of the government and the Ministry of Justice are the only way we can provide for the rule of law and the efficiency of protecting the rights and freedoms of individuals. In this law, there are bans and limitations on the freedom of association by the lawyers, the freedom of opinion and speech with regard to using Facebook, for example, in exercising that right. There are limitations on access of legal assistance and limitations on access to the courts as a whole. In this law, there is great scope for the Ministry of Justice in broadening their competency and setting it down in the new law. In the past, the Ministry of Justice, for example, could not initiate laws with regard to the work of lawyers, and based on our former law on the 5th of December of 1997, there were very many more guarantees for lawyers to do their jobs. And the competencies in order to provide for this assistance efficiently.
Distribution center, we have to move on. I would like to give the floor now to delegation of Kazakhstan, followed by delegation of Spain.
Thank you, Mr. Moderator. Общенациональный план
The overarching plan for Kazakhstan is done in accordance with the rule of law, and we haven't taken measures to reform legal procedure, and we also have amended a number of acts with a view to modernizing our judiciary. The law in question is based on 7 thrusts. First of all, to speed up procedures and reduce the time people are remanded in custody. And according to European standards, a person who has committed an offense can be remanded in custody for up to 48 or 72 hours. We have introduced 36 hours. And this is the time that is given to the investigative authorities to provide sufficient evidence in order to bring charges. We also aim to protect citizens' rights, and another thrust is to strengthen the adversarial principle. lawyers have the powers to turn to the investigative authorities on the basis of expertise, and the amount of time given to them in order to bring charges has been reduced. I will give my presentation to the Secretariat. Thank you.
Much appreciated. Keeping the time limit. Now I would like to give the floor to delegation of Spain, followed by delegation of Georgia.
Thank you very much. Judge Aveteto told us that judges should not be above the law. And he also quoted Mr. Maduro, who said that judges should not bow to the authorities. In the world, we are facing increasing case of fake news and ways of holding parallel trials, in a sense, which are parallel to the work of judges, which all are geared towards influencing the decisions of judges. So judges have to stand up to both the authorities and increasingly to public opinion, and to take decisions which run counter to what public opinion might say, or to what some media claim public opinion says. So Spain would like to appeal to all politicians here present and to all institutions to not use the media as a means to further complicate the already difficult task of judges who, with a single computer and their mind, have to uphold human rights and the application of the law. It is an undeniable fact that fundamental rights and freedoms are protected through the law and through the application of the law by the judges, and through the respect for the Constitution and the application of the Constitution by the judges. We must be aware that the OSCE and the Council of Europe, or the European Union, are institutions that were created with a view to foster peace in Europe. Similarly, constitutions and laws and courts have been created in order to protect human rights in Europe. Thank you very much.
Thank you very much indeed. I would like to give the floor now to the delegation of Georgia, followed by Non-Governmental Non-Commercial Organizations Association. Georgia, the floor is yours.
Thank you, dear moderator.
Sorry, это Киргизия, Кыргызстан.
Киргизия есть. Не переживайте.
Добрый день.
Good afternoon. I would like
Delegation of Georgia, please, the floor is yours, and Kyrgyzstan will follow later. Thank you.
Thank you, dear moderator, honorable colleagues. An overall of judiciary has been high on Georgia's reforms agenda since 2012. For that purpose, Georgia has successfully implemented 3 waves of judiciary reform to secure the independence of judiciary, and by that to consolidate an institutional democracy, a system of functional institutions in the country. The first wave of judicial reform brought about a more democratic, depoliticized, open and transparent High Council of Justice. Representative of the civil society and academia replaced members of the parliament sitting in the council, and TV cameras were allowed to the courtroom. The second wave of reform introduced a little tenure of judges. To this end, the clear and objective criteria for pro-life appointment, appraisal of judges, and transparent and objective procedure for final appraisal before the lifetime appointment of judges have been set. This and other achievements have been welcomed by the Venice Commission. These reforms led to significant reduction of application against Georgia in ECTHR. During 2010-2017, the number is reduced approximately 5 times. As to the size of the population, Georgia is the 12th place among 47 member states of the Council of Europe with the least number of applications. This tendency of decreasing application indicates confidence and trust the society has in political and legal institutions of Georgia, including the judiciary. In 2017, only 25 applications were communicated to Georgia by the European Court, 3 times less than in 2016. Under the 4th wave of reform, the Ministry of Justice of Georgia continues work on introduction of specialized commercial and tax chamber with the jurisdiction over high-profile commercial cases. This policy is a part of efforts of government to transform the country into the regional hub for the resolution of the business and commercial disputes. In addition, Georgia, as a chair country, hosted in July this year, OGP Global Summit has made significant contribution to the OGP values for openness and deepened democracy. More than 2,000 guests from more than 100 countries attended the event. The government is committed to continue reforms in the field of rule of law, judiciary, and human rights. Thank you for your attention.
I'd like to thank the delegation of Georgia, and now I would like to give the floor to Non-Governmental Non-Commercial Organizations Association. Пожалуйста.
Thank you very much. Distinguished colleagues, distinguished moderator, I heard something this morning is that Kyrgyzstan is an island of democracy. Well, the situation in the past 6 years has drastically changed, and I fully agree with that. I would like to note in Kyrgyzstan today, we have so many political prisoners and those who are prosecuted, is that we don't have anything similar in the neighboring countries. About 40 people that you may know as well, the former deputy, Mr. Busanov, Komnerev, the leaders of different parties, one of them who participated in presidential elections, amongst others. There are many, some are even from other countries. There's someone who's a citizen of Kazakhstan, the former son-in-law, Gedvayev, and also, of course, Mr. Askarov, as a result of many rights organizations and NGOs when they try to stand up for him were also victims of prosecution, and cases were started against them. I wrote about this in my reports, but I wanted to put forward a number of recommendations which could be included in the reports of international organizations, and to recommend to the new President of Kyrgyzstan, Jeenbekov, as the head of the government. We don't have a guarantor of the constitution, but we do have the head of the state who represents the unity of power and the people. In this case, I should like for the government of Kyrgyzstan to stop the we should stop the practice of dividing the branches and measures that put pressure on opponents. International monitoring is needed with the use of international human rights organizations and independent lawyers with regard to the politically motivated cases which are now being tried in Kyrgyzstan. And as the outcome of this monitoring process, we should look at the legal liability of judges and prosecutors who, just to keep their jobs, have been taking negative and dangerous decisions. And to recommend to Parliament.
You to submit your statement to the distribution
Спасибо.
center. Thank you, вам спасибо. Thank you very much.
Хорошо,
The
спасибо
next
большое.
speaker is Center for Democracy and Rule of Law, followed by the delegation of Tajikistan.
Thank you. My name is Taras Shevchenko, and I represent the Center for Democracy and Rule of Law, Ukraine. I want to pay attention to judicial reform that is going on in Ukraine and say several arguments about that. First of all, we as an organization evaluate Ukrainian judicial reform as a slight move forward to more independent judiciary. Slight with much higher expectations that Ukrainian people had after the Revolution of Dignity. And the biggest problem that we see, the biggest obstacle that this reform is not that successful and not that fast, is the idea that was put inside the reform that judges should decide about judges. The idea that was brought as European concept and also suggested by Venice Commission, I believe, was wrong, at least for current Ukraine. Having judicial branch which is absolutely not trusted, which is highly corrupt, and giving judicial institutions into hands of judges themselves was a mistake and is not allowing fast developments and fast progress into making judicial branch independent. Contrary, civil society has a huge support from the public and quite a big and progressive role in the process of judicial reform. Our NGO, for example, provides screening every candidate to the Supreme Court, and now will screen every candidate to the new anti-corruption court that is in the process of establishment. We will also maintain profiles, the database with profiles, currently having more than 1,500 judges, profiles of judges, having information about the integrity, media reports, and only sources on reliable media and investigative reports from reliable organizations. And also I want to stress attention to the fact that my colleague Roman Maselko, who is advocate, is currently threatening his advocate's license might be revoked, and he during the process of the judicial reform was one of the biggest advocates and lobbyists and the person who was protecting as advocate judges who were whistleblowers. We really want to pay attention to the case of Roman Maselko. Thank you very much.
Thank you very much. I would like to give the floor now to delegation of Tajikistan, followed by delegation of Kyrgyzstan.
Ladies and gentlemen, the Republic of Tajikistan constantly works to strengthen the rule of law and the judiciary in order to better protect human rights and ensure that the law is upheld. And this is at the heart of the government's attention. We have a number of laws which are aimed at bringing in amendments concerning laws, and we have 3 stages to our judicial reform, which is currently underway. We have adopted a new law on courts, and the courts of justice have been simplified, and we have also foreseen better equipment for the courts and better training programs. In order to enhance the democratic foundations of the staff and for ensuring that due process, we have a system for selecting well-qualified judges and for ensuring the independence of the judiciary and a fair process. All of this has been done largely thanks to active cooperation with international organizations in the framework of fulfilling obligations under the OSCE and the United Nations agreements with Tajikistan. And we hope to further work constructively in the field of human rights. One effective way to do so is to attend the annual Human Dimension Implementation meeting. However, in recent years, this platform has come to be abused, and a number of members always seem to speak to the same point, and that tensions rise and unconstructive attitudes hamper the good work of this platform. We hope that decisions will be taken in light of this to address the situation. People who have committed dangerous acts relating to extremism and terrorism have been admitted, even though they are on international search lists. And I would say that this does not allow for constructive dialogue within this meeting. And concerning the adversarial process, I think we need to consider reviewing the accreditation given to participants.
Followed by delegation of Azerbaijan.
Distinguished participants, Mr. Moderator, thank you for giving me the floor. The topic for this session is extremely important. The rule of law is the basis of any democratic state. The functioning of that state and its development depends on the rule of law. Without the rule of law, human rights cannot be respected. Kyrgyzstan is a part of the international community, and we have taken upon ourselves obligations to respect international standards, including in the field of the independence of the judiciary and the effective administration of justice, as well as fair and due process and access to judicial remedy. A new constitution is being adopted, and a key part of it was aimed at judicial reform. A judicial system must be transparent, and it should be the subject of public scrutiny. And it must, of course, be independent from any form of political prejudice or sympathies. And it should operate in light of the law and should respect the economic criteria as well. We have undertaken a great deal of work to reform the legal framework underpinning the actions of courts concerning the legal status of courts, guarantees for their independence, their impartiality, and we have also adopted a new criminal procedural code, as well as a civil procedural code, and most of these have already entered into force. The remaining ones will enter into force in January 2019. New procedures for appointing judges have been adopted, including age-related ones, and also provisions concerning the budget of the judiciary. The full statement will be given to the Secretariat. Thank you.
To give the floor now to delegation of Azerbaijan, followed by Institute for Reporters' Freedom and Safety. Delegation of Azerbaijan, the floor is yours.
Thank you, dear moderator. Without justice, there is no rule of law, no human rights, and no democracy. The independence and impartiality of the judiciary are fundamental to the rule of law. They are necessary for separation of powers and for confidence in the justice system as a whole. It's well known that special place in ensuring the independence of judiciary, particularly with regard to relation with the executive, takes the creation of an independent body of judicial self-governance, the majority of which ought to consist of judges. Today, the competence of the Council in Azerbaijan includes all the issues concerning the judiciary, particularly its exclusive powers include the organization of selection of judges, evaluation of their performance, career advancement, and questions of liability and reward. It is this principle on which Judicial Legal Council has been established. In terms of independence of judiciary as well as enhancement of confidence in court, the personality of judge is of high importance. Attaching a special importance to this factor, Azerbaijan has developed the most transparent system of selection of judges in collaboration with the Council of Europe. A new body was created specifically to conduct the selection of judges. The Judge Selection Committee, members of which are made up mostly of judges. The selection process is a multi-stage procedure that includes tests, written and oral examination, long-term trainings, local and abroad, with the participation of international judges and experts, as well as internship in courts. working conditions of judges, as well as the equipment of courts with the information and communication technologies also play an important role. Azerbaijan is implementing now a third project with the World Bank, main components of which are the modernization of judicial infrastructure and introduction of e-court. All court buildings are equipped with latest ICT, transforming the judicial bodies into high-tech courts. New courthouses have administrative and public areas, and both have separate entrances. The administrative area intended for judges and court employees, while the public area is envisaged for the citizens. At the same time, modern information booths have been installed to simplify people's access and raise their awareness, enabling them to easily and conveniently obtain information about trials.
I'm really sorry if I can ask delegation to submit the full statement of distribution center. Apologies for cutting you. I would like to give the floor now to Institute for Reporters' Freedom of Safety, followed by our last speaker, Public Foundation, Kilim Sharmi. So once again, apology, and if I can ask you to submit the statement.
An independent judicial system is completely absent with regard to the executive authorities. The president of Azerbaijan, Mikhail Aliyev, is well known in the world is that he has designated his wife to be vice president, and he also has the right to dismiss and appoint judges. The judicial system, which should be independent, is a subsidiary of the Ministry of the who is one of the ministry's head, who's headed by the cousin of the president. There is persecution. He's prosecuted. The courts have never handed down any non-guilty verdicts. My brother, Mr. Gusev, after a satirical article seen by millions of people on YouTube, he was subjected to torture due to kleptocracy and was sentenced to 2 years in jail. Over the past 17 months, over 100 trials took place where over 18 court judges from many different courts, not once handed down a not guilty sentence in spite of my brother being innocent. One of the lawyers was debarred by the executive authorities just because he was standing up for one of the leading political prisoners. Now, the judges have often been abusing their positions in order to get rich themselves. The people of Azerbaijan, which is the only source of power according to our constitution, has no right to initiate a constitutional referendum. Although the President Aliyev from 2001, when Azerbaijan became the member of the Council of Europe, the referendum.
The rules, and I ask you to stop this because it is not about the current topic, so please ask him. The moderator, please stop his talking because it's out of OSCE. And I'm repeating again, please. Please.
I should like the Secretariat to condemn.
Thank you very much.
Я говорил по топикам, а вы, пожалуйста...
He's not talking about the topic.
This is the topic of our session.
Of Azerbaijan that is out of the rule of the
yes, I also recognize the gentleman's
Thank you very much.
It was constitutional usurpation.
Second thing is I also recognize Azerbaijan has the right to reply, and this would be properly granted. Thank you very much. I would like to now conclude this session in a very constructive, professional manner and give a floor to the last speaker, Public Foundation, Kilim Sharmi. Thank you.
Thank you. I will start by a recommendation. Firstly, to call upon Kyrgyzstan to stop the practice of holding closed trials. For example, some political processes and trials have taken place of Mr. Gudiev and others who were sentenced to 24 to 28 years in jail. And even the ombudsman was not allowed to be an observer to these trials. The second recommendation is to stop holding trials against foreigners without interpreters. These were Iraqi refugees, a 75-year-old lady who only spoke Armenian without an interpreter. She was sentenced to 5 years of jail time. Thirdly, to call upon Kyrgyzstan when we look at human rights violations to make sure that they should be in line with international standards that have been ratified by the government. For example, Mr. Tungishbayev, he was applying to asylum in Kyrgyzstan. In spite of that, he was extradited after a court handed down that decision. My last recommendation is to introduce a law on a trial by jury. This law was supposed to be enacted back in 2016 if criminal trials are considered with regard to very serious crimes, high-profile political trials. If a jury is used, then not one court could influence the verdict of a trial where jurors are involved. And then the verdict would also be supported by society, but only if these are verdicts handed down by a trial including jurors. Thank you.
Last intervention finishes the speakers list. Now I would like to recognize that we have 14 delegations who would like to exercise 15 delegations would like to exercise their right to reply, and I would only encourage delegations to keep their right to reply to 30 seconds, maximum 1 minute. The first delegation will be delegation of Tajikistan.
Ladies and gentlemen, concerning the independence of the legal profession, the Qualification Committee comprises 12 lawyers, and decisions and statistics also show that almost 100% of the people who apply for the licensed practice law obtain it. In terms of quality, we would like to say that some lawyers have come under threat, and Tekiryuru, for instance, has been held to account not because of his professional activities, but because of offences he committed outside of his profession. And I would also say that only when there are national security issues are there any exceptions made to the regular practice, and that amounts to less than 0.1% of all cases.
Kyrgyzstan, followed by delegation of Uzbekistan.
Thank you. In connection with the mentioning of Kyrgyzstan by civil society, I'd like to use the right to reply and say the following. The NGOs mentioned a case, Yurgitsa, which is being examined in full accordance with the Constitution. One case is currently under investigation, and the Kyrgyz delegation provided information to the NGOs already today, and there's no need to repeat myself.
Since today we're talking about the rule of law, I want to say that the basic document in any country is the basic law. That is the constitution of the country. Under Article 70, the Republic of Kyrgyzstan is a sovereign republic in Kyrgyzstan. We have Article 115 that says that the trials are taking place in the language of Uzbek, Karalpaskan language, and other languages. And the Knesset needs to also approve the verdicts of local courts. So in accusing Uzbekistan in doing something that infringes upon the rights of the community of Pakistan are unfounded. The recommendation put forward by the second person from the NGO, he said that human rights organizations should come to Uzbekistan. Thank you for this recommendation. But for the past 2 years, many human rights NGOs internationally have come to Uzbekistan. The doors are open. This recommendation is already being fulfilled. And there was another proposal to accredit independent media. That was something we should have talked about yesterday, but today we want to say that we do continue to accredit them. Thank you.
Recognize that translators kindly agreed to stay with us only until 1:15. So please try to observe 30 seconds limit. The next delegation is Serbia, followed by delegation of Romania.
Thank you. The delegation of the Republic of Serbia would like to exercise its right of reply to the statement made by the delegation of United States of America. The Republic of Serbia is fully committed to the process of European integration, and in many occasions the Serbian authorities made it clear that they were fully committed to having a functioning judiciary within a functioning democratic state and were ready to tackle any outstanding issues to achieve this goal. Concerning the case of Brother Bitici, I would like to use this opportunity to iterate the unequivocal commitment of our authorities to bringing the perpetrators of all war and other crimes to justice, including this one. We can assure you that all relevant state bodies are involved in resolving this case and prosecuting the perpetrators. We believe that such approach should be applied in relation to all crimes which took place in Kosovo and Metohija. We believe it is important to work on addressing all crimes in order to achieve justice for the victims and their families and move forward with the process of reconciliation in the region of Western Balkans. Serbia has already done a lot in this regard and will continue to do so in the future.
Thank you very much indeed. The next will be delegation of Romania, followed by the delegation of France.
Thank you, Mr. Moderator. I would like to exercise the right of reply to the intervention of the distinguished U.S. representative. Concerning the modifications envisaged to the criminal and criminal procedures codes in Romania, Romanian government has the political will necessary to ensure the proper functioning of the rule of law by guaranteeing respect for fundamental rights and freedom in order to ensure the development of democracy and the combating of corruption. The concerns expressed were addressed during the recent visit of the Council of Europe Venice Commission to Romania. On this occasion, the experts of the Commission had a series of meetings with the relevant institutions, such as the Superior Council of Magistracy, the Constitutional Court, the President of Romania, and the Parliament. The cooperation with the Venice Commission, as well as with other international organizations that have expressed concerns, has continued and will continue. Romania reaffirms its commitment toward protecting the rule of law, independence of the judiciary, and to combating corruption as fundamental elements of a functional democracy. Thank you, Mr. Moderator.
Thank you very much. The next one is delegation of France, followed by delegation of Ukraine.
Merci. Thank you, Chairman. I would like to exercise France's right to reply following the statement made today by the association Salut et Miséricorde. France defends the freedom of religion and of belief for all individuals, whatever their religious faith. That is true for French citizens who are Muslims and for all other French citizens. Islam is the second largest religion in France. It is part and parcel of France's landscape now, and the 2005 law applies to France as it does to all other religions and guarantees the free right to worship. We would like to recall and remind Salut et Miséricorde that this session was dedicated to the rule of law, the right to a fair trial and things, and this is something that lies right at the heart of our debate. Thank you.
Delegation of Ukraine, followed by delegation of Hungary.
Distinguished participants, I wanted to note that the statement of the Russian Federation with regard to the secret detention of Russian citizens and torture against them in Ukraine are false. At the same time, I draw your attention to the fact that the Supreme Court in Ukraine, there continue to be appeals by citizens with regard to the Crimean courts after the occupation by Russia, because the occupational authorities refused to provide the information to the courts. The citizens did not reject their right to appeal. At the same time, I want to note that in November of 2017, the so-called Supreme Court formed by the terrorist organization on the territory of Donetsk region not controlled by Ukraine established capital punishment in spite of this being illegal, where Ukraine has, and these regions have signed up to international treaties. Terrorist organizations in territory not controlled by Ukraine in the region of Donetsk do not fulfill these international standards and do not have the right to have a capital punishment verdict.
By delegation of Azerbaijan.
Thank you, Mr. Moderator. In reply to the remarks of Mr. Hunt, it should be stressed that the new framework for the judiciary adopted in 2011 in Hungary has been carefully examined by the Venice Commission and the European Commission. These bodies have identified several positive elements in the Act, while also pointing out a few problematic elements that were addressed by the Hungarian government. Secondly, as a reply to the Hungarian Helsinki Committee, let me highlight that the recently adopted 7th Amendment to the Fundamental Law has created constitutional framework for the legislative work necessary for establishing the institutionally independent administrative judicial system. The organizational separation of administrative and ordinary courts is justified on the one hand by the particular purpose of the administrative justice. A fair balance has to be created between private and public interests, ensuring consistency between the basic right of the individual and the legal protection based on public interest. On the other hand, adjudication of administrative disputes requires special knowledge and a particular attitude of the judge in order to be able to protect the citizen from the superiority of power of the inevitably dominant authority.
Thank you very much. I do apologize. I have to now give the floor to the delegation of Azerbaijan. The floor is yours, please.
Thank you very much. I would like to exercise the right of reply concerning the comments raised by U.S. delegation. Responsibility in democracy is a very important case. Each opposition activist, like each citizen of Azerbaijan, should take into consideration transparent and responsibility for himself. Everybody is equal before the law. Azerbaijan state is not interested to apply travel ban on its citizen. But there is decision of court we have to respect, as we do concerning some OSCE participation states. And I ask to follow the rules to make statements on current topic, as comments about the opposition activists are not a subject about the session. Thank you very much.
Very much. I would like to give the floor now to the delegation of USA, followed by the delegation of Holy See.
Thank you. The United States is not a party to the Rome Statute and accordingly has strong objections to any assertion of ICC jurisdiction over American personnel. Second, Maria Butina was indicted with conspiracy. According to the affidavit, Butina worked at the direction of a high-level official of the Russian government. Third, the detention of enemy combatants captured in armed conflict is lawful. All operations at Guantanamo Bay comply with applicable law, including Common Article 3 of the Geneva Conventions against and the Convention Against Torture. Finally, we reaffirm our support for religious freedom in the OSCE region. We should not attribute the views of some members of a religion to all. Thank you.
Okay, Ambassador, and I would like to thank interpreters for staying with us this extra quarter. Thank you for your hard work, and I do understand that you also need to have a break. So we will continue without interpretation, and I apologize for that. The next will be delegation of Holy See, followed by delegation of UK.
Thank you, Mr. Moderator. I take the floor to exercise my right of reply to the intervention made during this session by the International Humanist and Ethical Union. The point made by the Holy See in its opening statement, based on the words of the Holy Father, is that a lack of a shared understanding, reflecting a common view or approach to our consensually agreed upon commitments related to universal human rights and fundamental freedoms, has had and continues to have a detrimental effect on the OSCE's human dimension, which could have consequences for security and cooperation among states. The intervention of the IHEU and its argumentation, not to mention its unfortunate misrepresentation of the position of the Holy See, confirms our point. Thank you, Mr. Moderator.
Thank you very much. The next will be delegation of UK, followed by delegation of Latvia.
Thank you, Mr. Chairman. The Russian delegation made a brief allusion to the British judicial system, and I'm happy to
use the opportunity to agree with Professor Murray. There can be no democracy or human rights without rule of law. As our present Lord Chancellor and Justice Secretary recently said, rule of law is the bedrock of our democracy and at the heart of our way of life. Our judiciary is independent, its decisions and the operation of our courts must be respected and free from improper influence or interference. Mr. Chairman, British judges appointed on merit to open competition have a responsibility to provide fair, impartial justice. Their decisions have to be made on the basis of facts and the law, impartially and free from external pressures. These are important principles which underpin our system of justice and our commitment to the rule of law. They are the bedrock of our democracy. Thank you.
Thank you very much indeed, Ambassador. And I would like to give the floor to the delegation of Latvia, followed by delegation of Czech Republic.
Dear moderator, in reply to several speakers mentioning my country name, first, I would strongly agree to remarks of Mr. Moderator to keep on today's topic. Second, Latvia strictly adheres to the rule of law principle. If criminal or other proceedings take place, it happens only as prescribed by law, in accordance with the principle of judiciary independence and accordance in the Latvia's international obligations. Third, one of the speakers, namely Mr. Kozirevs, is representing one political party and is running for the general elections in a couple of weeks. I regret attempts by active politicians to use this platform as part of pre-election campaign. Thank you.
Thank you very much. The next would be delegation of Czech Republic, followed by the last delegation on the list, delegation of Armenia.
Thank you. I would like to exercise right to reply to the statement of the Religious Society pass of Guru Jara. In the Czech Republic, the right to fair trial, freedom of religion, belief, tolerance and non-discrimination are safeguarded by the Constitution and by the law. They are fully in line with our international obligations. Thank you.
Thank you very much. And the delegation of Armenia, please.
Thank you, Mr. Moderator. My delegation was not able to make statement under this session, hence I will bring forward the key priority of Armenia related to the topic of the session by reacting to the statement of the US delegation. We thank the US for its reference to the anti-corruption policy of the Armenian government. In this regard, we would like to stress that people of Armenia gave strong mandate to the new government to fight and eradicate corruption. The independent judiciary is key in successful anti-corruption policies. Armenia is, finally let me reiterate that Armenia is ready to cooperate with all OSCE actors in designing and implementing anti-corruption policies. I thank you.
Thank you very much indeed. Let me conclude the session by first of all thanking our excellent introducers. And I do apologize, I was going to give you 2 minutes to sum up the discussion, but the only thing I can do is to encourage all of us to go back to your remarks which have been submitted to the distribution center, and I'm sure they're going to be an excellent read. I would also like to thank all of you for very constructive and professional participation in this session. This was a very vibrant session. Apologies that we have not managed to finish on time. I would like to once again thank the interpreters for staying with us this additional 15 minutes. I would also like to remind that the speakers list will be open 1 hour before the next session, and I will strongly encourage you to register as we have a limit of 50 participants for each session. If I can also remind you to leave the handsets and receiver in the room and encourage you to participate in a number of side events who started a few minutes ago. Thank you very much indeed.